We're at our appointed time. Okay, and let's see, I see Shannon, she was here. She's online now. She should go back to her desk. Okay. Oh, okay, okay. And I saw Catherine. Catherine, would you mind confirming that you can hear us?
I can hear you.
Excellent. Thank you, Catherine. So we have a two-pronged agenda this evening, as was sent out very kindly early in the last week. And our two objectives this evening, first is a training session, which is the work session. And we'll more formally introduce our guests, but everyone knows County Counsel Vance Croney, and we have Ross Williamson from a law firm in Eugene, an expert in governmental and code kinds of things. We're very much looking forward to that training session. And then we have a general meeting that will follow, and that has some business items for our attention. So let's begin with a roll call. And so let's see, Commissioner Bisco.
Present.
Commissioner Irish. Commissioner Wilson. Present. Commissioner Lee. Here. Commissioner Cash. Here. Commissioner Struthers was going to dial in. I don't see him listed on our participants. He may dial in. I think he had an engagement he was going to try and dual task. Commissioner Fulford. Here. Vice Chair Heyman. Here. And I am present, Nicholas Fowler. Director, could you perhaps continue with introductions of you and your team? Yes. Back table.
Chair Fowler?
Yes.
I cannot hear anything that Director Nichols was sharing. I can hear you clearly, but I could not hear anything that anybody else that was introduced.
Thanks for the reminder. It's a good reminder for all of us who are
turn our mics on.
Turn the mic on.
Thank you, Catherine. All of our microphones should now be on. For these little mics here, you want the green light. Mm-hmm. For the stand mics, you want the red. So I know that's confusing. All right. So Catherine, just to recap, we introduced Alyssa Thompson and Linda Ray, who are the support staff for the Planning Commission, to help us with minutes and making sure we have the room set up correctly. Very much appreciate Alyssa and Linda, and food. Yes. Mm-hmm. Thank you. And then I was just introducing Patriot Sheets. Patriot, do you want to tell everybody who you are?
Patriot Sheets, I'm planning director.
So, and then of course, you know me, I'm Darren Nichols, Community Development Director. Other county staff here is Vance Croney, County Counsel. Yeah, very much. We lean on Vance often to help us with legal questions. I'm not sure you want to introduce guests, our guest.
No.
That was definitive.
Not gonna do it. And then it looks like Commissioner Struthers has joined us.
Oh, okay. Very good. Welcome, Commissioner Struthers.
Are we going to introduce Patrick? Did we do that and I didn't hear?
Good evening, commissioners. I'm Patrick Wingard with Department of Land Conservation Development. I'm your field rep, your regional rep out of my Springfield office. Really happy to be here tonight.
Happy to have you. Let's move into anyone that we omitted. Good, let's move into our work session, and we've consistently had continuing education as one of our objectives. And so we very much appreciate the help of Petra to pull together this session, but it's intended to be very interactive. We've got two experts here in all things being a planning commissioner, the pitfalls and where we might go wrong, as well as best practices and what we might do appropriately. Both are prepared to take questions, but also have kind of an outline of how to get into the materials to warm us up. So let me turn it off over to Mr. Williamson and Mr. Crony.
Good evening, everyone. Patrick, I don't know if you got a copy.
Oh, there's an extra one here.
All right, so I'm gonna walk around a little bit, and I know I'll try to stay close to a mic, so you pick me up. I don't do well behind the desk, and I like to see faces, and if you're glazing over, then I'll know to move on. And I also can pick up questions this way too. So my name is Ross Williamson. I'm an attorney at the Local Government Law Group in Eugene. We are a 7-attorney law firm, hopefully 8 soon. And all we do is represent small local governments. So we represent a lot of cities throughout the state and a lot of special districts like fire districts and water districts. And we do special projects for counties, a lot of labor negotiations actually for counties. And we also are general counsel for Gillum County. So we do county work as well. I've been doing this work I started with the city of Eugene when I was a baby lawyer, and that was about 22 years ago. And so I've been doing local government my entire career. And even before that, I was a government wonk, public policy for the state of Washington, worked for the Washington Supreme Court. And I really like government. I think government is made up of people who are trying to do the best job they can. And so I am very sympathetic to government employees and the job that government is trying to do. So I guess I want to also say thank you for being planning commissioners. It's a highly paid job, I know. So it's a really good one. But without you all here, then the work doesn't get done. And I think having a citizen planning commission is part of the transparency of government. And so it really helps people connect with government, and it helps you all connect with what's going on in your community. So I think it's great that you're here. It's great that you're want to learn more. And like the chair said, this is going to be, I have an outline. My slides are in front of you. And we're going to go through the slides, but if you have questions, please let us know. And then Vance is gonna, as you all know, your county council, he's gonna step in and correct me when he needs to. And then he's also gonna talk through some of the local flavor, local process, because I don't practice in Benton County because he's got the monopoly on that. So he's going to speak to those local issues, and then I'm going to talk to the more general issues. I'm trying to keep it to 2 hours or maybe a little under, so we don't keep it too long. I do love the sound of my own voice, so we're gonna do my best to keep it to 2 hours. I've got lots of liquid to keep going, so that's a problem for you all. So here's an outline of what we're going to try to talk through tonight. We're going to start with some public meetings law because this is a public meeting and you all work through public meetings. So it's, even though you have very educated and dedicated staff to help you with these things, it's good for you all to understand the public meeting requirements as well. And we have some new legislation to talk about. We're also going to talk about conflicts of interest. So we're going to talk a little bit about ethics. And your duty under the ethics laws. And then we're going to talk about, then we're going to get into the real land use stuff. And so we're going to talk about legislative land use processes. What does that mean? And then we're going to contrast that with the quasi judicial land use process. And we're going to spend a lot of time, I think the bulk of the second half of the presentation is going to be on the quasi judicial process because that is kind of the meat and potatoes of what a planning commission does. All right. So the 2023 legislature gave us House Bill 2805. And I think maybe we have to, before we can talk about 2023, we have to go back in time a little bit. We can go all the way back down to the 70s when the Oregon Public Meetings Law came into being. The Public Meetings Law is known as a Sunshine Law. It was developed in the 70s, kind of around the time of Watergate and Nixon, and people were tired of backroom deals, and they were tired of handshakes in the dark and not knowing what their government was doing. And in particular, in Oregon, we had the Newspaper Publishers Association really wanting to figure out what government was doing so they could report on it. And so it was a sunshine law. Government was supposed to take place in the sunshine. So that was in the 70s, and the law has not changed much since then. So we have a 1970s law, and we have Zoom, which was not considered back then. Go figure. So we have judges and courts trying to interpret, and learned attorneys trying to interpret 1970s law and apply current technology. And so that's where we get some of the, sometimes Vance says, well, this is what I think the law is, because there is no real answer. We try our best to give you the best advice, but there isn't always a straight answer. We also have, in my hometown of Eugene and Lane County, in 2011, we had a case called Dundee versus Handy. And then a little bit later, we had a case called Handy versus Lane County. In those cases, tried to interpret what a meeting was under the law. When you think about it, in 1970s, they said, well, when people get together, that's a meeting. Well, in 2010 and 2024, what does it mean when people get together? Is a Zoom, when no one's in the same room, everyone's in their separate spaces, even in different countries, is that a meeting? When we are texting each other, is that a meeting? How about if we don't have the whole quorum, but then we have different people from that subgroup then going out and meeting with other people, is that a meeting? The law doesn't say. So we have a court that gives us some opinions about what does it mean to meet. And so in that Dundee case, in that Handy case, we got some rulings from the court in Oregon that said, and this is where that notion, you've probably all heard the term serial meetings. This is where the notion of serial meetings comes from. So that means we don't have to be in the same room at the same time to have a meeting under the Public Meetings Law. We can be exchanging texts, we can be exchanging emails, we can be on Facebook, and if under certain conditions, that could be a meeting. Well, in 2023, the legislature thought, well, it would be good to enshrine that in the law. So let's make a statute, let's codify those cases and turn it into our law. So, meeting under the statute is the convening of a governing body, of a public body. A governing body just means a group that is in charge with providing recommendations or decisions, and a public body is the county. So a governing body of a county, and your board is a governing body, the planning commission is a governing body, the budget committee is a governing body, for which a quorum is required in order to make a decision or deliberate towards a decision on any matter.
So, Rob, so just as a point of clarification, not every single committee that the county creates is a public body, but for the chart, for their bylaws, we call out that it is a public body to make sure there's no misunderstanding that public records, public meeting law does apply to that.
Yeah, so Vance is on top of it. Getting out in front of it.
So this is from the 2023 legislation?
No, so this is
That's the 1970s.
this is the 1970s law.
Okay.
This is how the meeting was defined.
Okay.
And so what House Bill 2805 did is define those two highlighted terms.
Okay.
And so we defined convening and we defined deliberate, because those were the terms that were talked about in those Lane County cases. And now we have some statutory definitions. And we actually have a county council from Washington County that drafted this legislation. He takes no credit for anything else in the legislation. I might have gone to sleep. So the term convening, so convening of the group, what does that mean? Well, statute now gives us a meaning, a statutory definition of what that means. And if you look at subsection C, it actually uses that word, using serial electronic written communication among participants. So now we don't have to rely on case law, we rely on the statute to say, okay, if you're exchanging emails, electronic communications among participants, then that is within definition of convening. Subsection D is using an intermediary to communicate among participants. So this is a good one. So you're a body of 9, so a quorum is 5. So if 4 are talking outside of this room, that's not a quorum. And so that's not a public meeting. But let's say the chair is one of those 4. I'm going to pick on you a lot just because we've talked before. And so, no disrespect. So Nicholas is in that room with 3 others. And you're talking shop, you're talking land use, you're talking county planning. That's not a meeting, because it's just 4 of you. It's not a quorum. But then he talks to you 3 and says, well, what do you think about that issue? And he's taking your opinion and he's putting it in his pocket. And what do you think about that issue? Well, he's taking your opinion and putting it in his pocket. And then he goes and talks to 3 other folks. So all of a sudden, it's just 4. Now it's he, Nicholas, and 3 others. So it's still 4. That's not a quorum. But he's got 2 opinions in his pocket. So he is the intermediary.
Okay.
So he is taking the opinion of 2 others and now creating a quorum or a possibility of a quorum. So you have to be careful when you're talking shop, even when you're outside of a quorum, because you don't want to be that intermediary. You also don't want to let someone else be that intermediary.
And does that pertain only to a land use action under consideration, or can it be any topic under the sun?
Well, we're going to get to that next slide.
Okay.
I love it when people think ahead. This is great.
This is convening is defined.
Yeah,
Okay.
yeah. So we're going to talk about
That
deliberation on the next slide.
Okay.
So this came out of that Lane County case, because what we had in that Lane County case is we never had, it was the Board of Commissioners in Lane County. There were 5 on that board. We never had 3 of them in the same room at the same time. But we had 2 of them talking to all 5. And we actually even had, the facts of the case are outstanding for a lawyer. We actually had one of the commissioners with a spreadsheet with 5 names down one side and yes, no across the top.
Oh my gosh.
And so there were check marks. And so, yeah, if that's not an intermediary, I don't know what is. So that's what the statute is trying to get at. All right, so now we have deliberation. Let's see the second newly defined term and what a meeting is. So the term deliberation is now defined as discussion or communication that is part of a decision-making process. So to answer your question, yes, it's something that is on the agenda, something that you're working up towards on the agenda, something that is conceivable for the future, something land use related. Just because I'm a lawyer, note that the term meeting used the word deliberate, and yet they define the term deliberation. Is that going to be a problem? I don't know. We'll see.
I have a question for you.
Yep, yes, please.
So those two things have to happen together,
Yes,
not separately.
right. Yeah. So you are serial communications about a deliberation.
And they define deliberation, but the term deliberate is in the law?
Yeah, so
Okay. Oh, right, so deliberate, okay.
deliberate is the defined.
Is the defined
Is the
term.
term, and yet
Okay.
they define deliberation.
Okay.
Little details, things that we pick up.
So just as an example, we met by Zoom to kind of prep for this work session. If I had polled every one of the planning commissioners about what their interests were, that's not a decision-making process, but it is an agenda topic. If I had done that, did I break a meeting law?
Well, I would work with Vance to argue in your favor that no, we weren't delivering, but it's pretty close to the line because we have an agenda item that is training for the board, and you are saying, I'm now taking a poll. What's important for this group? Well, shouldn't that be done out in open?
Mm-hmm.
Shouldn't we have that discussion so other people, maybe the audience, can say, no, you guys don't need to learn about that. That's stupid. So the point here is transparency.
And to be clear, we didn't do
No,
that.
And also scheduling is not.
Yes, Petra, excellent, reading ahead in the slideshow. So we also have now under the statute, 3 exceptions to the meeting law. And these are exceptions that are part of that Dundee Handy cases in Lane County that the court said, we're not worried about these issues. And so now the statute says, okay, we're really not worried about these issues. And so the first exception is purely factual or educational in nature with no deliberation or decision on any matter. And so I think the and is important. So it's purely factual or educational in nature. And that can mean no deliberation or decision on any matter that might reasonably come before the governing body. So I think so it's not just any education. It's not any factual information. It's got to be that and too. So I think these training sessions, you could argue, well, we're just training. We're being educated by Vance and Ross on how to be a good planning commissioner. Well, we're learning about stuff you do about all the time. We're learning about land use. We're learning about quasi-judicial processes. Some questions may even come up about past actions or maybe even future actions that could be on your agenda. And so we want to be careful about education. Where I have said it's okay for like a city council to meet outside of a public meeting for training is when they are having personality issues, maybe, naming no names, and don't know how to communicate with each other. And they need to learn how to talk politely with each other. And they need to bring in a consultant to tell them how to communicate with each other. And as long as I am positive that they're not going to talk about examples from their agenda, then I will probably say that's okay. That's pretty rare because the examples that come up are always about work, right? So it's really hard for a city council or a board or a planning commission to have those types of trainings that don't involve somehow stuff that you're going to be deliberating on.
And I will add another example. By statute, the Benton County Board of Commissioners has to tour the jail once a year. Annually have to go to the jail tour. There is no deliberation. They do go, and it is purely informational. The sheriff leads it. It is not a public meeting, and I tell them all, don't talk amongst yourselves. There's a very good reason for this, because we really can't hold a public meeting in the jail.
Right.
So they are, I walk to the offices and I explain to them what you can and cannot say. And then they go through that jail tour. It takes about 45 minutes. But again, it's just utterly impractical to consider holding a public meeting in the Benton County Jail. So that's an example where it's purely educational. They don't exchange information, and it fulfills a statutory purpose.
Yeah, great example, Nancy. Thanks. An example of what doesn't fall in this exception is, someone on a planning commission, you have a land use matter before you involving a certain piece of property, and you drive by and take some pictures of it. And then you share those pictures with your fellow commissioners. I was just sharing pictures. That's all I'm doing, sharing pictures, purely factual information. How much more factual can it get than sharing pictures? Well, it's about a piece of property that is on your agenda, and you're going to be deliberating about it. And so that is essentially providing evidence to the rest of them. The second exception that is no longer a meeting under statute is this one, not related to any matter that at any time could be reasonably foreseen to come before the governing body for deliberation and decision. I think this is probably the social gathering exception. When you're going to talk about your kids and you're going to talk about your great new barbecue recipe, that is never going to come before the planning commission, even though it's a great barbecue. Very tender. And even though my kids are fantastic and I know you want to see pictures, that's never going to come to the planning commission. So I think that's what this is covering. It's also covering things that are just never going to, and for the planning commission, this is probably easier than the board, that are never going to be on your agenda. So you could talk tax policy, gun policy. That's never going to be on your agenda. And so I'm pretty confident that would be within this exception. And then Petra's exception here. This is the non-substantive in nature, such as communications relating to scheduling, leaves of absence, and similar matters. And so this is the classic. You get an email from staff saying, hey, Tuesday doesn't work for a lot of folks. Can we meet on Wednesday? You can hit reply all, we hate that. But in that certain circumstance, you could hit reply all, and that would not be a meeting because it's just administrative. For some of my city clients or small district clients, it's, hey, we need someone to come in and sign checks. Who can sign checks? And you get a bunch of people back and forth saying, well, I could do it Tuesday, I could do it Wednesday, how about 2 o'clock? All that communication is just administrative in nature, and that is not a meeting. I'm going to talk pretty quickly to keep things rolling about what else House Bill 2805 did, because it's not a super concern for you all because you've got great staff that will help you out. But 2805 requires training for all members of a governing body. And so the Oregon Government Ethics Commission will be developing training that is required for all of you to attend, even though I've just told you everything about the law. So I don't count.
So there's a separate training.
There's going to be a separate training.
Gotcha.
It is going to be held by OGEC staff, or they're talking about approving curricula from other providers. I understand the League of Oregon Cities might be providing a curriculum for approval. I don't know if the counties association is or not. I suspect not. I'm pretty sure that my firm is not going to try to get approved by OGEC. We don't really like them telling us how to train our clients. We think we do a pretty good job, and we'll leave it at that. I suspect it'll be online training, so at least you won't have to go to Salem. You'll be able to log in and somehow certify that you did it. It's required once per term. So you all have 4-year terms, I believe. So you only have to do it once every 4 years, unless you're filling a vacant position, in which case that term could be shorter. So if someone left with 2 years in their term and you were appointed to fill that 2-year term, you may have to do that training sometime in that 2 years. And I'm sure staff will be on top of this as soon as OGC is on top of it. So this bill has been in effect for almost for a year. And their website still says to be decided, it's coming. Watch this space for more news. So that's unfortunate. They got funding for 5 new staff members to do this training. So they're still working on it.
This section on the County Historic Resources Commission. Are we considered a governing body? When you hear public hearings, make decisions on alteration of historic resources?
I would say yes.
So will we be getting training as well?
If every county committee would undergo the training, and I don't think you were here when I said it, but I'm sure your bylaws describe the Historic Resources Commission as public body, so yes. So pay attention, all of this applies to you.
Yeah, so there are going to be some kinks with this training piece, because I think there are some unintended consequences that potentially the board could appoint an ad hoc committee to provide them information about one particular issue. The county jail, or a bond, where we want to go out for a new jail bond or a law enforcement bond, and we want to get some citizens together to provide us a recommendation. In and out real quick. The term is 2 meetings. The term is 4 meetings, 2 months. Well, I have to get trained once per term. How's that? I mean, so you got to think through this stuff, and they're still thinking through.
And so if I just a point of order is that this is just bonus, this training.
Oh, no, this is the icing on the cake. What are you talking
Well,
about?
bonus, I said bonus, I mean, in the sense that there still will be, OGC will still require us to attend in some form or fashion their training that they have developed.
Exactly.
Okay.
Yes, exactly. All right, and just really quickly, because this is truly a staff issue mostly. So the law also provides a grievance process for public meetings. They gave the OGEC jurisdiction over public meetings as well as executive sessions. So up until House Bill 2805, Ethics Commission had a jurisdiction over complaints about executive sessions, but not public meetings. That's why we had that big Lane. That's why we had that big Lane County litigation, is because someone had to sue about the problem. Now someone can complain to the Ethics Commission, and they have 5 new staff people to help with all those complaints. So if Vance really screws up, if staff really screws up, and you're holding a public meeting without the proper notice, or maybe at a location that is not accessible, or maybe it wasn't even noticed at all, and you're in someone's backyard, well, someone can complain, and then staff will have to respond to that complaint within 21 days. So it's a pretty quick turnaround.
And these are complaints filed by the public?
Yes.
Okay.
Yeah.
Yeah, and that's really a topic that you won't bump into unless, you all get together in somebody's backyard barbecue and you start chatting about an application that's pending for you.
And the neighbor overhears that.
Yes, it doesn't like the fact that he wasn't invited.
Right.
Yes.
Exactly.
Yes.
Okay.
But staff does take care of notice requirements, setting the location and making sure that the little details of public meeting law are met. So you guys can focus on things that you signed up for, just not the administrative tasks.
Absolutely right. Yeah. And I guess I will also say, I'll just add on to that, because I like the sound of my own voice. So this statute comes out of that Lane County case, and that Lane County case was just so egregious and it was just over the top. You know, it was not only, you know, keeping a list of what the votes were, they were meeting across the street at the bar, 2 at a time. Literally at the Hilton across the street. It's now the Graduate, but they were at the Hilton, the bar, talking about whether to hire secretaries or not. And it was so over the top. And the public meeting was, the newspaper was in the back of the room, the commissioners came out, there was a motion, a second, a vote, and then they left. And the newspaper's like, wait a minute. That was a huge decision. They just spent $200,000 in a blink of an eye, and no one said anything about it. I bet someone did say something about it, but it wasn't there. And so it was just so egregious. So, I mean, if you are ever in the position of wanting to say something about business, planning commission business, but being afraid to do it in public, that should be a red flag. You should have these discussions in public. You have to have the thick skin to do this job. You have to be able to talk to your colleagues. You have to be able to communicate with them and tell them how you really feel about the issue, what you really believe about the issue. And if you want to have that conversation because you're too sensitive outside of this meeting, that's a red flag. So that's the main point of this, I think, is have those conversations here in this room. New topic. We're going to talk ethics, and specifically, we're going to talk about conflicts of interest. There are lots of ethics rules that we could talk about, but today, because we're talking to a planning commission, conflicts of interest is the most important, I believe, to get through in 2 hours. So we're going to talk about conflicts of interest. And when we are talking about conflicts of interest, we're not only talking about the public official, which is you. You all are public officials. Staff are public officials. But we're also talking about the relatives of the public official, which is kind of an expansive list, but not super expansive. So when we're talking about conflicts of interest, you have to be thinking about your own pocketbook, the public official's pocketbook, the financial interests, but also that of your spouse and your children, your sister, your brother, your parents, your son-in-law, daughter-in-law, anyone that you have a legal support obligation for, so maybe not on that list, but maybe through a second marriage, you have a support obligation, or maybe from a divorce, you have a support obligation for someone. If you have a support obligation, then they are a relative. And also someone who is on your benefits. So if you're at work and you list a non-relative on your benefits who's receiving healthcare from your job, that's also a relative. So the list is not huge, but it's not small either. So you got to think about that. And we'll talk about what that means in some examples. Not only are we talking about you and your relatives, but we're also talking about your businesses and the businesses with which you are associated. And so a business with which you are associated means 3 separate things. First of all, it means a private business with which you are an owner or an employee, basically. So if you own a business or you're employed by a private business, they are a business with which you are associated. So you have to think about their pocketbook now too, in these conflicts rules. If you own a bunch of stock in a public company, so say you have $100,000 of Boeing stock, well, now it's $50,000, so maybe it's not a problem. But back in the day, if it was $100,000, I'm from Seattle, so. So if you are a big shareholder in a public company, that is a business with which you are associated. And then lastly, if you generate a bunch of income from a business, so maybe you're your spouse has a great pension plan, and you generate at least 10% of your annual household income from a particular business, that is a business with which you are associated. So sometimes for us attorneys, it's, I've seen ethics cases where a retired attorney is on the planning commission, but is still receiving some payments from their former firm, and that former firm shows up at a planning commission. That person needs to think about, oh, that's a business with which I'm associated.
It's not likely that Boeing's gonna show up here, though, huh?
Right, that's right.
But it's not
unlikely.
It's not unlikely
Yeah.
that Oregon State, the Hewlett Packard, the Good Samaritan employee would have more than
Right.
10% of their household income.
True.
We have a number of large employers in town.
So we just went through, 5 slides of definitions. So, and we haven't even started talking about conflicts of interest. So when you have a conflicts of interest issue and you bring it to staff, as you should, before the meeting, Vance is going to ask you a lot of questions. And he's going to pry and pry and pry into your personal life. He's going to ask you about your family. He's going to ask you about your relatives. He's going to ask you about your income, your jobs, your employers. And it's going to say like, whoa, Vance, take it easy, man. I'm just talking about a conflict of interest here. Well, ethics issues are so fact dependent. And he's asking you all those questions because the definitions matter. And this is what makes or breaks an ethics violation. And so it's going to be quite a process. I don't want that to scare you away from Vance. He's doing his job, but he's going to ask a lot of questions. And so you're going to have to come prepared to answer those questions, and he'll help you through the process. But it can be a little intrusive.
And I will say that that could happen, but it's almost certain that if you come to me and ask the question, do I have a conflict of interest? You're coming because you know you do. So I'm not gonna have to get into details. I can think of 2 planning commission hearings where I've had to meet with a planning commission member beforehand. That person ended up recusing himself and then herself, a later one. And one of our commissioners, I don't know if any of you remember Jay Dixon. Jay Dixon was a board of commissioner member. When he came onto the board, he owned an Ace Hardware store. And so that ownership interest presented conflicts with a couple of things, economic development topics, for example. So it's pretty obvious. It's pretty obvious. And again, you know, you're learning from Ross things to look for. And if that red flag begins to go off in your head, chances are pretty good you know it, and then I'll know it, and we can go from there.
Yeah, that's such a great point, Vance. So we're not going to answer all of your ethics questions tonight. So hopefully we're going to give you the seeds with which to ask the right questions and to raise those red flags. And so if you remember a year from now, God, Ross was saying something about business with which I'm associated. Is that, I just got a windfall of stock. What does that mean for me? Well, I'm asking those questions now. And so that's the purpose of this training, is to plant those seeds so you know when to ask questions, and then reach out to staff, reach out to Vance if you've got issues to bring up. I also want to point out just a couple things in terms of ethics in general. I deal with the Ethics Commission, and my firm does quite a bit. We represent a lot of different government clients, and Government Ethics Commission has oversight over all of them. And so we deal with the Ethics Commission quite a bit. They have a brand new director, Susan Meyer. She was an investigator, and so now she's risen up the ranks, and she's now the executive director. She's tenacious. She's a very good, she's an attorney, used to practice in Arizona and moved up here to be an investigator for the Ethics Commission, and leaves no questions unasked. So when she calls, pick up the phone and help her find the right answers. But she's pretty tenacious in her job. But I will also say that she is pretty fair. So we've actually seen an increase in investigations over the last maybe 5 or 6 years among, Oregon-wide, because of some statutory changes that aren't germane. But we've seen a lot of increase in investigations, but also an increase in settlements. So they will point out that you've done wrong, and they will show some mercy on you. And generally, especially for planning commissioners, and then especially if it's not too egregious, it's often a letter of education, which is the best type of violation penalty to get. I mean, your name will be published, but it won't be a penalty or a fine. It'll be a letter of education. So that's kind of the trend we're seeing over the last several years. But I will also note, ethics commission, obligations are personal. So we're going to help solve and answer questions beforehand to keep you out of trouble. But if you find yourself in trouble, that's when it's on you, unfortunately. And so if there is a fine, that's coming out of your own pocket. You can't turn to Vance and seek reimbursement.
Don't turn to me anyway. And just as a matter of comfort, we have never had an ethics violation that resulted in a fine to an individual. So we've had election law violations that have resulted in fines. And again, those are also personal. We've not had a ethics violation at all. So don't be the first.
That's right. All right, so now we're actually going to get into the topic. Actual versus potential conflict. So we're going to talk about conflicts of interest here, and the whole analysis is will happen versus could happen. So that's what we're going to be talking about here. We're going to talk some examples, so stay tuned. Don't jump ahead. But first, the rule. This is an actual conflict. An action, decision, or recommendation by a public official, you all, that will happen, will result in a financial benefit or detriment for you, the public official, or a relative, defined, or a business with which you are associated, also defined. So, an action, decision, or recommendation. So that is you acting in your capacity as a planning commission, making rulings on applications, making recommendations to the board about changes in the code, making recommendations about all manner of planning issues, anything that comes on your agenda. That's an action, decision, or recommendation. And notice also that it is that will result in a financial benefit or a financial detriment. So if you are bad at being unethical, you can still get in trouble.
There are those terms defined, financial benefit and financial detriment.
No, but financial benefit is seen as gaining money or not losing money.
But there are line of sight financial benefits, and then there are halo effects.
Sure, well, that comes into the will.
Okay.
Oh,
Good question. Yeah, so that's when we get into will happen versus could happen. Exactly. Okay. So now let's talk about, we're going to get into some examples, but let's talk about what a potential conflict is. It's very much the same with one change in word. It is an action, decision, or recommendation by a public official, which means you, that could result in a financial benefit or financial detriment to you, your relative, or a business with which you are associated. So let's talk about examples. And so I just want to flag, so I handed out this ethics commission opinion letter. we're not gonna go through it. I just thought this was, if you're a glutton for punishment,
Extra reading.
you can take this home and read it. It's actually pretty interesting for a planning commission. It should be interesting reading because it's about land use decisions. It's from the city of Springfield, and it's looking at a land use code update and how different committees within the city were making recommendations and decisions on that land use code update. And whether there was a will happen or it could happen conflict. And so it's interesting. That's just to take home. So let's talk about examples. When do you have a conflict of interest? Let's talk about a code update. So you all have the Benton County Development Code, the zoning code, where you regulate all the lands in Benton County. And you all are asked by staff or the board to make a recommendation on code changes. So that comes before you and you debate it. You maybe even have a public hearing, hear testimony, and you provide a recommendation to the board about whether the code should be changed or not. Legislative actions for you all as the planning commission are never going to be a will happen because you're just making a recommendation. We don't know that the board is going to take your recommendation. They may totally disagree with what you all have to say, right? Recommendation accepted and rejected. So it is always going to be a could, because someone else is making the final decision. So that's actually, I mean, that relieves a little stress right there, right? So that's good. But let's talk about where you could have a actual conflict. And so you have an application in front of you. And let's say your sister owns a piece of property in Benton County and submits an application for a conditional use permit.
I have to recuse.
And so the staff works up the conditional use permit. Maybe they make an initial ruling on it, and your sister doesn't like the ruling, so she appeals it. It comes to the planning commission. So the planning commission is going to be a final decision maker on that appeal.
It's a will.
And whether you agree with your sister on that appeal or don't agree with your sister on that appeal, it will have a financial impact on her because she wanted to develop that property in a certain way. And so, again, even if you're bad at being unethical, even if you disagree with your sister and say, I don't agree with you, we don't want to issue their CUP, you've just caused her a financial detriment, which is still unethical. So you can stand up, I'm not being unethical, I just caused harm to my sister. Well, sorry. She is a relative, your sister is a relative, and that the action decision will have a financial impact on her, whether you vote yes or no. So that is an actual conflict. So what do you do?
So where the planning commission board is the final deliberative body.
Yeah, so
In other words, in that first instance, we didn't make a final decision. We simply sent a recommendation to another body to make a decision.
Right.
That's could happen.
Right.
Or could.
Yeah.
The second example is that we are the final arbiter. We're the final decision makers for that petition or appeal or whatever. And that is a will happen.
Yeah.
Conflict.
But it's not, you're not the final decision maker. It's possible that could be appealed to the Board of Commissioners. But when you reach a decision that could be final, that's a will.
Okay.
Yeah, so that's a great clarification, Vince. I have not seen the Ethics Commission actually address that issue. I've looked several times over my career. But so, and there are cases where the board is technically not, it could not be, there are decisions that the board makes that could go on appeal, and there could be another decision maker. But ethics doesn't worry about that. If you are final decision maker on that matter, then that is a potential for an actual conflict. That's
Regardless of what the petitioner may do beyond that point.
right, because it could be a final decision.
Yeah.
So what you do when you have a potential conflict or an actual conflict, you show up at the meeting. Well, first of all, you identify the conflict and you talk to staff beforehand. And you say, I'm going to come to the commission meeting with a conflict, and this is what I'm going to do. So give them a heads up. Staff love to find out beforehand. Trust me. And then they can help you with the script. They can help walk you through the process. It's really painless, but it's great if they know beforehand. So what you do is during the meeting, when the recorder is on, when the minute taker is taking minutes, you state the nature of the conflict. And so for our example, with my sister owning a piece of property in the county, applying for a CUP, you would say the nature of the conflict. My sister is the applicant. My sister owns that piece of property. The decision before us concerns my sister's property and will have a financial impact on her, whether we vote yes or no. So I am declaring an actual conflict. There's none of this standing up and saying, oh, I have a conflict and just walking away. That is not sufficient. And the Ethics Commission will ding you for that. The very first question that Susan Meyer asks when she gets an ethics complaint is, please send me the minutes from the meeting. Because I want to see what was said. Did that planning commissioner announce the conflict? How did they announce it? Did they fully announce it? Did they describe the nature of the conflict?
What if you choose not to participate at all in the meeting? You still need to declare a conflict.
So as in not show up?
Yeah.
Well, then you're not, so you're not at the meeting, so you can't declare it. Yeah.
However, if that meeting is continued,
Right.
Sure.
and then you show up, you haven't thought this through.
And you're bad at being bad at ethics.
That's right.
Yeah.
Yeah, so you have to state the nature of the conflict. You have to do it before the discussion. So that's an important piece and so your quasi-judicial script, I'm sure you have one. And so you ask, are there any conflicts of interest? And you do that at the beginning of the agenda item to give everyone the opportunity to declare that conflict first up. And you got to do it on the record, so the recording's going, and you have to do it at each meeting. So if you're in a legislative land use matter, you're considering some code updates. Code updates can take a while. You can have several meetings about a code update, and you're declaring a potential conflict every time. But it is golden to say, Susan, here are the minutes of all of the meetings. At the beginning of every agenda item, I announce the potential conflict. See? Go away.
So then does that individual then recuse and leave as if it were going into executive session? I mean,
I love this. You're skipping ahead.
oh, sorry.
No, I love it.
Okay.
This is great. You're engaged. I love it. So for an actual conflict, you do the same. You state the conflict, state the nature of the issue, and then you do not participate. So sometimes folks like to come down from the dais. That's not required. Although it does, in certain circumstances, it does paint a good picture. So I don't object if someone, especially if you're up there winking, nodding, passing notes, behind the dice, like, what's going on over there? I'm not participating. So yeah, sometimes stepping down is a good. I don't know if you have a.
Yeah, and I always ask you to step down.
Okay, great.
Because the public perception piece of this topic is crucial. if somebody declares an actual conflict of interest and still continues to sit at the dais,
Mhm.
the public's gonna wonder what kind of message that's sending, are they communicating with body language? But if you step down, either leave the room or sit down,
Or
it's perfectly
be part of the
it's
public.
within your right to sit in the audience.
Mhm.
Now the public sees not only has he declared a conflict of interest, but he's removing himself from the decision making. It
Right.
just paints the rest of the planning commission members in a better light.
Right.
I'm totally fine with that. It's not required, but I totally agree. Yep, absolutely. So the difference between an actual and a potential is will happen and could happen on the front end. On the back end, it could happen, full participation. You just announce the potential conflict and fully participate and vote and everything.
Okay.
So there's no harm to you in declaring a potential conflict if you have it. You just announce the nature of the conflict. I own some property in Benton County that could be impacted by this code change. But it's going to the board for final action. So our recommendation is not a final action, and so it's a potential conflict. And so I'm declaring that every meeting. And then I'm going to continue to participate. I'm going to give my opinion to my colleagues, and I'm going to vote. It's only for an actual conflict where you have to get down and no longer participate. And I will say, and then this is another kind of trend that I've seen with the Ethics Commission, they are really pretty strict on will happen. So we really have to know for sure that there's going to be a financial impact. And so the scenario of there's an application in my neighborhood. One of my neighbors is going to develop their property. Is that going to impact my property value? That is so hard to know. That is so hard to know. I mean, there are some certain circumstances where maybe your immediate next door neighbor is building a pig farm. Yeah, that might impact me, and we can probably know for sure that's going to impact me. But if one of my neighbors in my neighborhood is building a new house, putting in a new stable, putting in a new barn, is that really going to impact? I don't know. I don't think so. Maybe, but we don't know for sure. And that's one where the Ethics Commission will say, no, it's not certain. That's not a will. That's a could. So that's one of the benefits we get from that.
And it's only triggered by financial. If it's like empathic, like it upsets you.
Right, yeah.
Only if it's financial.
Right, yeah. So, yeah, the legislature doesn't legislate morality. Yeah, right. Yeah, this is just financial interest. Yeah.
So you can't,
Financial benefit or detriment.
there's no grievance for hurt feelings.
Right,
Okay.
right. Yeah.
So I guess this is a question for Council Crony on such a potential conflict. Do you err on asking us to declare those? Since it's only a potential, like the example that Mr. Williamson is using, if you happen to live in the same neighborhood and it's not clear at all that there is a direct line of sight from this land use action to your property values, you err on the side of declaring a potential conflict.
Yes, because to me, that's insurance. You have just saved yourself from a challenge at the Ethics Commission. Even if it's, a tenuous connection, what have you lost? So yes.
That is exactly right, because that's how it works out. So there's a complaint filed, Susan picks it up and looks at it, gives Vance a call and says, hey, can I see the minutes? If the minutes show you declaring a potential conflict, she'll do 10 minutes of work, making sure it's not an actual, and then she'll recommend dismissal. Oh, you don't have to, no lawyers involved, no nothing, it's great. So, yeah. So just real quickly, it is not a conflict of interest. And you may have heard this before. If you are a member of a class that is being treated equally by the decision. So the common scenario is a legislative action, a code update that is impacting all residential property in the county the same. Now, the thing that a lot of folks don't see is the underlying wording there, that the commission determines is a class. So you don't get to declare the class, they get to declare the class. So this is another reason if it's not a sweeping class, if it's more fine-tuned, if it's an area plan and you're in that area and you think everyone's being treated the same in that plan, but maybe not, get out in front of it, work with Vance, and we'll get that to the Ethics Commission to have them declare whether that's a class or not. And so and unfortunately, they meet every 6 weeks. So you really have to get out in front of it. But they're the only ones that declare a class. Second exception is membership in a nonprofit. My classic example for planning is Habitat for Humanity. So say you're on the board for Habitat for Humanity, and they have a land use application in front of the Planning Commission. That is by statute, not a conflict of interest. You don't have to declare anything.
Okay.
Now we're gonna talk some land use. I'm very low-fi in my slide deck.
But you got colors.
But now, this is my one color slide.
Yeah.
It's really beautiful.
And of course, I stole it from someone else in my office. I don't even know who made that. So Oregon land use, you all know this stuff, but you are under the weight here in Benton County, at the Benton County Planning Commission, of a lot of law on top of you. We have the state statutes that created our whole land use system to begin with. Senate Bill 100 created, that's why Oregon looks different when you're driving I-5 compared to Washington and California, is Senate Bill 100. So we have state statutes that regulate land use across Oregon. And then we have LCDC, the Land Conservation and Development Commission, that created the 19 statewide planning goals. Those are the overarching planning goals of the state of Oregon. And we don't have any coastal dunes here in Benton County, do we? So we don't have to worry about a couple of the goals, but otherwise a lot of the goals apply here. And then we have LCDC rules, administrative rules, OARs. They have a lot of rules that govern land use in Oregon as well. And so all these things are starting to stack up on top of your shoulders. And then here in the county, you have your own county comprehensive plan. So part of Senate Bill 100 is saying, hey, everyone in Oregon, we want you to develop a plan for how you will develop into the future. In cities, it's a 20-year plan. So I don't know what.
It's 20-year.
Yeah,
20-year plan.
It's in the process of.
Yeah,
20-year plan.
20-year plan. So you have a comprehensive plan that then dictates decision-making for the next 20 years. And then you have a zoning map. So you've looked at Benton County and you've broken it up by color, and you said what uses are appropriate for each little zone in your county. And then you have your development code. And so all of this is on top of you. And Patron knows it all by heart now, as your planning director. And so this is Oregon land use. And so you are a cog in the Oregon land use scheme. And you have, when you get a staff report on a matter, you have staff that have looked at all of this stuff, and they have done a lot of work to get this teed up for you to make your decision and your recommendation. So that this kind of explains why maybe those staff reports can get pretty long. It's because they're looking at a lot of stuff. There's a lot of regulation that comes down in the land use area. I guess I will also say, especially in the legislative session that is just about to end, we're getting little carve outs these days. So we're having the state say, well, we have this land use scheme that is developed this way, but we're gonna treat this differently. We're gonna treat that differently. And housing is one of those, especially for my clients, the cities. We're having a lot of decisions being made at the city level on housing issues that are specifically excluded from this whole land use scheme. And so those appeals don't go to LUBA anymore. We don't have to worry about a lot of the goals anymore. Sometimes we don't have to worry about our own development code anymore. We're just build, build, build. We're building housing. And so that is kind of a little carve out we've seen recently. It pains some of our long tenured land use professionals. It kind of like, oh, we work so hard to know what's going on, and now it's different. Another little carve out that we don't have on my little slide here is the Constitution. So sometimes we get a land use decision and we have to take into account the Constitution, the United States Constitution or the Oregon Constitution. What's an example of that? A takings. So if we have a development that comes in and files an application in Benton County, and we have a code provision, maybe we even have a comprehensive plan provision that requires them to do something on their property before they can get that permit. There is the potential that the applicant can say, hey, wait a minute, that's a taking. You are exacting money or property from me in exchange for my development. And that's not roughly proportional under the Nolan and Dolan. I don't know if you've heard those terms. Nolan and Dolan are two US Supreme Court cases that talk about takings under the Fifth Amendment of the US Constitution. And they describe when an exaction is roughly proportional and can be imposed. And so sometimes you can get a staff report that has the criteria and it will say, we're not applying this criteria because we can't make it roughly proportional to the development. And so you have this whole scheme of criteria that says developers have to take certain actions and do certain things. And then all of a sudden your staff is telling you, well, we have a constitutional problem. So we can't, so that's an exception. We're not dealing with it. So that is something else your staff have to work through. All right, at the local level. Predominantly, we have two classes of matters that come to the planning commission or come to the county in terms of land use. We have legislative land use matters, and we have what we call quasi-judicial land use matters. Not quasi, quasi. It's a law school joke.
Or pseudo.
So legislative, just shorthand, legislative land use matters is policy making. We talked about code updates. When you will very likely never have an actual conflict. Those are legislative land use matters where you're making a recommendation to the board. Quasi-judicial land use matters. That is when you have an application in front of you, like the one for my sister for a CUP.
Okay.
When you are acting like a judge.
So Ross, yeah, can we go back one slide? We do a planning commission orientation with every new planning commissioner, and we talk about those in terms of the purposes of the planning commission. So the first purpose is to recommend changes in code to the Board of Commissioners. That's the legislative. The other is to hear matters, applications that come before the commission. That's the quasi-judicial. And then the third one is to serve as the committee for citizen involvement for Benton County. So our bylaws have three major functions: legislative matters, quasi-judicial matters, and then community involvement or citizen involvement. So anyway, we're all experts on that now, but just to kind of connect the dots there.
And that community involvement is a requirement of the 19 land use. It's goal 2, right?
Goal
1.
Yeah.
Right. So that's a requirement of those 19 goals. So that's great.
Involvement specific to land use.
What's that?
System involvement specific to land use.
Yeah, that's right. In the land use process.
All right, so what is a legislative land use matter? It is making policy decisions that apply to many. So a broad application. It's generally not starting with something called an application. Sometimes can be, but it's not, usually not. Sometimes it's staff saying, hey, we've got some code provisions that we need to update, or it's the board saying, hey, I want you all to make a recommendation to us on something. And so that's not an application. You have wide discretion within the limits of all that state law that we saw on our shoulders to make a decision. The discretion includes sometimes making no decision. So sometimes the recommendation is, no, we don't need to make a change. That's actually a legislative land use matter saying, no, we don't need it. Our recommendation is not to do anything. And then of course, predominantly the planning commission recommends and then the board acts. So you are almost always at a recommendation, making the recommendation for the final action of the board.
And getting back to public meetings law from the beginning, a decision not to make a recommendation is a decision.
Right.
Yeah, so that happens. Yeah, tying it all together. That's just great. Yeah, so making that recommendation happens in a public meeting. That doesn't happen outside of a public meeting. So those are the basic characteristics of a legislative land use matter. What's the basic process? The basic process is we're going to talk about quasi-judicial a little bit, and we're going to see how regimented it is. For a legislative land use process, it's much less regimented. But there are still some requirements. So we generally have to provide notice to the public. Not only just our meeting notices, but sometimes there's special notice that has to go to certain members of the public if we're concentrating about changing zoning in one particular area that will impact some owners of property in Benton County. We're going to provide them special notice. We're going to provide DLCD with Form 1 notice about a proposed legislative land use change. And then we're going to have a planning commission meeting, or 2 or 3 or 4 or 5. There's no limit. So that's not, we don't have to make it in a certain amount of time. We can take all the time we want. And we can have several hearings with the public, lots of testimony if we want.
Ross, can we talk?
We can be here until 2 a.m. If you want to make a recommendation, it's usually you have to put together some kind of written document to send up to the board. It usually sets out some findings. Staff will help you prepare that, will prepare that. And it's going to have all the authority for the action, the procedures you follow, and it's going to say how it was consistent with all of those other laws that are on top of this. All right. In contrast, quasi-judicial land use matters. So what are the characteristics of a quasi-judicial matter? It is judgment. It's a good term. Quasi-judicial is being a judge. So you're putting on the black robe. So all of those the Law and Order that you watched for years and years, that's it. It's putting on the black robe and making a decision. And like a judge, it is applying specific criteria in your code. So if a judge is ruling whether someone committed the crime of arson, they're going to look at the elements of the crime of arson and see if they met each criteria of the crime of arson. You don't have to deal with arson, but you deal with a CUP. And so you look at all of the criteria for a CUP and you decide whether the application met each criteria. You're going to receive testimony and evidence and those are going to be directed at those criteria for the CUP. You're going to sometimes act as an appeal body too. So when staff make a decision and then that gets appealed to you all, that can be a quasi-judicial matter. So sometimes you are the initial decider of an application in a quasi-judicial matter, and sometimes you are the appeal body. Those are both quasi-judicial matters.
Does every single quasi-judicial decision originate from an application?
Ooh, yeah, it would. I think it would have to be an outside application. Well, or an inside application, but it's usually site specific. So somebody's asking to do something on their piece of property, on their project, as opposed to changing the criteria in a zoning designation, for instance. I think it would have to be driven by an application.
That's what I think.
Yeah. So Ross, I want to ask a question here about the testimony and evidence must be directed towards the applicable criteria. Whose job is that?
It is the writer of the decision. So the chair has a tough job in a quasi-judicial matter.
Yeah.
Because the chair is knowledgeable of the criteria, understands what's going on, understands what the chair's colleagues want to hear about. But then you have testimony from someone that is talking about, this application makes me sad.
Again, feeling.
That's
Sorry.
not a criteria. Sadness is not a criteria.
Right.
So my general advice is within reason, that person gets their time. They get to speak.
Yeah.
And they get to talk about how this application is making them sad. And then in the written decision, we say, we heard from testimony from individual Jane Doe, John Doe, and they were both very sad. That is not relevant to the case. And so we're not taking that into consideration in our decision.
So I think just to parse that down a little further, that during the hearing, it's the chair's obligation to run the meeting, run the hearing. But the staff typically drafts the findings, and it's the staff's responsibility to tie the evidence to the criteria. Obviously, you guys look at the draft findings and make your edits and recommendations, but it really does originate with staff first. It's always been done that way here, and that's not, it doesn't have to be, but it just makes sense that staff is the keeper of all the evidence, has access to it all day long, and let's face it, that's what they get paid to do. So you guys have other jobs, other things you do during the day, and it just makes more sense for staff to create that draft staff report that you guys approve.
So in that circumstance, is it possible then that there are written submissions from the public on that application that might be incorporated in the staff report presented to the board?
Oh, absolutely.
Okay.
Absolutely. Staff report will incorporate whatever's available at that time.
Sure.
But the draft findings will reference the entire record.
Right.
Because by that time, the record is closed.
Okay.
But I don't know that there's much submitted by the time the staff report gets written, other than the application.
Right.
Although we often leave the record open for a week after, because that's the applicant's right to ask for an extension. We have to automatically grant it. And so after the staff opinion has been written, we will often get a body of written evidence that comes in.
Right, and then the draft findings are revised.
Yeah.
And then they're revised following your deliberations as well. Take into consideration what you all have focused on, what you all have, how you tie the evidence to the criteria.
Okay.
So, Pedro.
Oh, I was just gonna share what you can expect from me unless I'm directed otherwise on this point, right? Because we still haven't had an opportunity to do one of these yet, but, so what I would do is all public comments are going to go on the record, regardless of the relevancy, right? But at the beginning of any staff report, I generally choose the public comments that can be tied to criteria, and I have a really liberal kind of assessment of that, so that there's no question, and highlight those items. So these are things that you can consider in your quasi judicial decision-making. But keep in mind that, exhibits A through F are additional public comment. They just not germane to the decision that we're making this evening. So that's kind of what you can expect to see from me at the beginning of a staff report on public comment.
Unless there's a well-schooled member of the public who's decided to pick on a particular criteria in part of the process. I guess what I'm saying is that there could be comment or comments that are submitted that actually address a specific criteria.
Yeah, you want to see those.
Yeah.
Those are helpful. You're always really appreciative of the public comments that come in that are actually attached to a page number or a criteria number or something like that. There's also another kind of delineation, which is someone bringing up criteria that's not relevant to that particular application. They're saying, looking at a TSP and trying to apply that to something that's not relevant. You can note that they've identified criteria, but it's not, again, part of the criteria for this decision-making process.
Okay.
So.
And I don't know, Darren, if you were getting at this, but I think it kind of goes back to something that Vance was talking about in terms of ethics and the transparency we try to provide the public. And the perception of our decision-making process. And so if someone is testifying and we all know it's irrelevant, sometimes it's just better to sit through that 3 minutes of irrelevancy than cause a scene, make them feel bad, make it look like we're shutting them down, make it look like we don't want to hear what they have to say because they're talking the truth. Sometimes it's just better to let them get it out.
Yeah, but we're on very firm footing if we limit a person's testimony to 3 minutes and we enforce that.
And you inform them at the outset of the hearing.
Okay.
And preferably in the notice.
Right.
Super preferably.
So that's kind of where I was headed was we got to hear people have to have an opportunity to share. And our chair knows this. The way that we manage that is by communicating the time limits. It forces testifiers to get focused in their comments and address the criteria. And if they want to go on for minutes 4, 5, 6 on other things, that's the purpose of the time limit, is to say, you had your 3 minutes or whatever it is. Yeah.
And practically speaking, you guys all sat through those hearings where it's just the applicant and maybe their neighbor. Yeah, you might have the 3-minute time limit in effect, but the neighbor goes on for 4 or 5 minutes and nobody really cares.
Right.
But when you've got a packed house and you need to move through, then it becomes a little bit more incumbent upon the chair to be a little bit more deliberate with enforcing those time limits, just so you can get through.
So I just wanted to discuss our role in this too. So we have a process where we kind of do a query, a roundtable discussion of our votes before we vote. And it's up to us to have an opinion that's based on criteria also and be able to express ourselves with relationship to our code and goals.
Absolutely. Yeah, absolutely. And so that's why the staff report is just so important. And it's, I will add to what Petra was talking about, the development, and what Vance was talking about, the development and the redevelopment of the staff report. You can have an application that comes in. It seems to be pretty tied up. It seems to be pretty good package. And then you start seeing testimony floats in, the neighbors understand, oh, this application's coming in. So I'm going to start sending stuff to Petra. And so Petra's there, it's 14 days before the hearing. She's drafting her staff report. It's 7 days before the hearing. She's got to get it out. Testimony is still coming in. It's just pouring in. And then, so she's like, she comes to the hearing and says, well, I gave you a staff report, but in the preceding 7 days, I've received this mountain of testimony. And so this is what I'm going to put it on the dais here for you all to see. And now we're going to revise the staff report. And then you have the hearing. And so now we have more testimony. And so this staff report is very much draft. until it is final. And it's quite a process. I mean, I have a lot of sympathy for planners who are just, especially on complex matters that are, generate a lot of testimony. And so then it's incumbent on you all to also help staff to like, okay, we don't see that as relevant to any of the criteria. Staff, explain why you think it is, or vice versa. And so you can have those questions for staff. You can say, I saw this letter come in. I think it's relevant for criteria A and C. And staff can explain, well, this is why we think it's not. And so you can have that discussion. So we're going to get to Vance to talk about your local stuff, but I'm going to talk about just the basic process really quickly and kind of a thumbnail sketch here. This is the 10,000-foot view of quasi-judicial action. And so we're contrasting to the legislative process we just talked about that has some notice to property owners, maybe notice to DLC, any number of hearings, no set time limit. Now we have a quasi-judicial matter, and there are set procedures that we have to follow, and your staff is going to remind you about. And so we have an application comes in, they paid their fee, and staff takes a look at it, and they do what's called a completeness review. They look at the application and see if there is evidence that touches on all of the criteria. And then there can be a back and forth with the applicant. Hey, I think you're missing some information. The applicant says, yeah, okay, I'll provide some more information. Or sometimes the applicant says, no, I'm not going to provide any more information. All right, it's your application. Then we provide notice to the neighbors. Then we do an evidentiary hearing. This is where we develop the record. And we produce a written decision. All quasi-judicial matters end with a written decision signed by the chair that says this is how the planning commission decided the matter. And we got to do it all within the timeline, either 120 days or 150 days.
150.
150.
Yeah, 150.
And for all intents and purposes, you all don't have to worry too much about the 150-day rule because your work is at the front end. Staff will manage your continuances, your open record periods, to ensure that there is enough time for an appeal to the Board of Commissioners and for the Board of Commissioners to conduct its hearing and most likely a continuance built in. So that time frame seems like a long time, but it goes surprisingly quickly when you actually lay a calendar out and start thinking about all the required elements that have to be met. Open record period, request for continuance, appeal period, etc. So you guys don't typically have to worry about it. Just know that if Darren or Pedro says, we really need to hold this continuance no later than 7 days, and you need to make a decision, she'll tell you it's because we're beginning to bump up against that 150-day clock. So staff does manage that for you.
Can you speak to a writ of mandamus? What
Writ
happens?
of mandamus, you don't want to bust the 150-day timeline. If Benton County fails to reach its final decision that has been reduced to writing, and that would almost certainly going to be the Board of Commissioners. Can't imagine you guys taking 150 days. Then the applicant has the right to go to the court, file a petition for a writ of mandamus, asking the court to order Benton County. The burden of proof shifts to show why the application should not be granted. It is a complete flip-flop of the burden of proof. And here's the biggest thing for me, attorney's fees. The other side is entitled to attorney's fees.
Okay.
But, and I can tell you, having talked to the judges many times about land use, they hate it. Because they never see it. They never ever see it. And so we do them a favor by not blowing the 150-day timeline and allowing the opportunity for the applicant to go into circuit court. Now, we have blown the 150-day timeline a couple of times, and I have worked with the attorney, and honestly, they try to read the tea leaves. just because you blow the 150-day timeline doesn't mean your application is gonna be denied. And so really, the applicant's attorney has to make an assessment. Do I think I stand a better chance in circuit court with the judge who never sees land use? Or with the board of commissioners who seem to have been liking the arguments that I was putting forward?
Yeah.
So 150-day doesn't necessarily mean the application is granted by the court. It just means another forum is available.
And the applicant has the right to waive or extend the 150 days for an additional 215 up to a full year. But that is the applicant's discretion only. We don't get to say that. We usually put that on the table right up front. When we got a complicated one we know is going to take time, we try to see if they'll grant us an extension or waiver. And some will, but some won't. They just will say it's got to be done in 150. So.
And Director Nichols, please correct me if I'm wrong, but from assuming a complex application, staff and internal process can take 60 days from completeness. So of the 150 internal processes might take 60 days before we get the evidentiary hearing. And then on a complex application, we might leave the record open, or if there's a lot of public testimony, we may have multiple evenings where we have to schedule a notice and so forth. So our process can take another 30 to 45 days. That's why that 150, it can get queued up pretty quickly. And then the board, it's a de novo application. They start all the way from scratch. So they need all that time to work through the evidence as well.
Yeah, that's correct. So our goal, we operate under the 150-day deadline because we're a county. So counties have 150 days. In front of that 150 is a 30-day completeness opportunity. We try to use that full 130 days to review, discuss with the applicant, make sure we've got all the information, give ourselves kind of a running start at the application. If you think about that in total, it's 180 days, it's 6 months. So our goal is to use the 30-day completeness plus the first 60 days of 150, the first 3 months, to do all of the public notice, information from public, writing the staff report, and then getting that to you. So there's a full 3 months on the back end to get to the planning commission, and if necessary, an appeal to the board. Even that is very tight. It just does not give us a lot of time. And we've been exploring that. It's one of the nice things about having Petra on board is she has land use experience. She gives us a bunch more capacity to actually track that stuff and kind of make sure that we're hitting those deadlines. But you should also keep us honest and timely, because if we start pushing much past that 60-day period, that cuts into potentially into your deliberation time, or it forces the applicant to ask for a waiver. And that's okay. It's understandable. Some applications are so complex that everyone understands this is going to take more time. But if the applicant chooses not to waive, it puts a burden on us to move fairly quickly. Yeah.
And since our hearing is an evidentiary hearing, is there any presumption of adversity between the county and the applicant?
No.
So there's no presumption of an adversarial pro and con.
No.
Right.
No, the baseline is county staff, planning commission, board of commissioners are objective, unbiased.
Establishing the record.
Yep, that's all. And in fact, at the end of the day, you all may be viewed as biased, air quotes around it, because you made a decision. But really, all you're doing is assessing the facts as presented, evaluating the events criteria, and making a decision. Staff should not be doing it. Now, staff could be viewed that by an application if the recommendation is to deny the application because perhaps, they haven't submitted evidence relating to, undue burden on public facility. But again, that's not taking a side, that's making a recommendation based on the evidence that they see. So we should be and should present an objective, unbiased stance.
Good segue.
We provide recommendations.
So one of the other hallmarks of a quasi-judicial land use process are acting like a judge. And so that means no bias, no ex parte contacts, and addressing conflicts of interest. And we'll talk about those. I have 3 slides left, and then we'll turn it over to Vance.
I have 3 minutes left.
I know, yeah. So what does bias mean? As a quasi judicial decision maker, the applicant and the parties involved have a due process right, a constitutional right, to have you all be unbiased. That doesn't mean you can't like your neighbors. That doesn't mean you can't have feelings about the lovely trees we have around here, the great farmland. You don't have to be a blank slate. But what you do have to be able to do is make a decision based upon the record, the evidence, and the testimony, and the criteria. So what does that mean to be biased? To be biased, and this is right out of Luba case law, some good examples. We had a city councilor on the coast who ran a campaign for city council as anti-development, anti-condo. I don't want any more damn condos in my town. Got elected because that was the sentiment in the town. And then sure enough, they get a condo application as soon as she gets on the council. And the applicant's attorney comes in and says, well, counselor, I think you're biased because on this day and this day and this newspaper, these are all the times that you said you don't want condos. And so that creates a pretty strong case that this counselor is going to be unable to put that aside and judge the application in front of her based upon the record and the criteria. But you have attorneys on your side who can do what's called rehabilitation. So if someone says, Chair, you're biased. I know I saw you at the grocery store the other day and you were complaining about the new pig farm that's coming in. And I think you prejudged this application. And so I think you're biased. And so I want you off this case. Well, you have an attorney who would stand up and say, well, Chair, can you explain yourself? What were you really saying? What really happened at the grocery store? And even if you have feelings about pig farms, can you put those aside and make a decision based upon the evidence and the criteria? Yes, Vance, I can. I can do that. Well, we have rehabilitated you, and I think you could then sit and make a decision on that application. Because to be biased means incapable of putting those things aside. The evidence for that city councilor was so overwhelming. She ran a campaign on anti-condo. Letters to editor for years about anti-condo. Signs in her front yard. That is the evidence that is needed to show bias. If you don't have that, and you can say in front of everyone during the hearing, I can put all of my feelings aside. I will make a decision based upon the evidence, based upon the criteria. Then, Chair, you can make a decision.
Well, Ross, I've got a question for you. So we haven't had a bias issue pop up. And in the script, you read at the outset, it says, does any commissioner wish to declare a conflict of interest, bias, or ex parte contact? How do you know somebody's going to challenge you for bias at that point in time?
So my script has the chair ask the audience.
Okay.
Oh.
So after you ask your fellow commissioners, does anyone have a bias? That you then turn to the audience and ask, does anyone in the audience wish to challenge a commissioner for bias? And if no one says anything, then that is a great record at LUBA for us lawyers to use to say, we asked. And now they're bringing it up. No. We gave them the opportunity. We asked, and they knew all of this beforehand. They were just sitting on it. That's not fair. They didn't give, yeah, they didn't give me the chance to rehabilitate myself. Because if they had challenged me, I would have said, I can put that aside. And I would have been verbose in my ability to put that aside.
But you get the question into the record
Yeah.
to the audience.
Yeah. Okay. So that is a change in the script that I have made.
I'm curious about something. If we're verbally complaining about big pig farms in the grocery store, depending on what we're, judging or deciding on, is it sometimes just better to step away than to challenge that on a public perception? I mean, is it like a case by case? So maybe you could put your bias aside, but.
So if you're complaining about pig farms while you're reaching into the bacon case.
Yeah.
I was buying hot dogs.
I mean, would there be times that you're like, okay, I'm really not biased, but.
So this is my my government walk and experience. I want you to vote every time you can. I want you to be able to do your job. I think the county is paying for 9 commissioners, and they should get 9 commissioners. Unless there is an actual bias, unless there is an actual conflict. And so I understand the perception issue, but I think that is where you acknowledge it. You said, yeah, I'm sure some of you heard me be anti-pig before. I know I've got a bit of a, talk around town is that I'm pretty anti-pig. And I will confess that I probably said anti-pig things to some people around there. But I want you to know that I take this position very seriously. And I am committing to you all to put that aside and judge based upon the evidence and the criteria. So I think that is a great way to head it off at the pass. Good question.
Ross, are there any
That is good.
consequences for folks who have like a serial recusal issue? They just don't want to make a decision, but is there a consequence for that besides, or is it actually considered an ethical issue in any circumstance?
No, so if someone is continuing shirking their duty of voting, no, other than the appointing authority has some potential authority there, but it's got to be pretty bad to get to that point. So I think you're on for 4 years and you serve out your term. If you don't do a very good job and just continually abstain from voting, I would pull them aside as an attorney. I would say, you need to do your job. That's why you're getting the big bucks. You're serving your community and you are not serving your community. There is no reason for you not to vote.
Can planning commissioners have rescission?
So our county code has a provision that allows the board of commissioners to remove any member of a board
For cause.
for no reason, without cause. So
Without cause.
that could be invoked in this situation, but it would have to be a real problem. Because again, the public perception component will play into that, but there is a mechanism for that.
Mm-hmm.
All right, I'm going to go back one slide. So a quasi-judicial decision maker has to have no bias and no ex parte contacts. So what is ex parte contacts? Verbal, written, visual contact, not in the record.
Mm-hmm.
So the holder of the record is planning staff. They present the record to you. That record is submitted during the open record period. During the hearing, testimony is part of the record. Evidence submitted during the hearing is part of the record. All of that is in the record. If you have things in your brain that are not in that record, and you want to make a decision based upon that, that is ex parte. That includes, and we talked about, Nicholas and I talked a little bit about this beforehand. There's a lot of smart people in this room on your planning commission. They have a lot of experience in other areas. There could be some pig farmers here. that know everything there is to know about pig farming. If that information is not in the record, that's ex parte. Even if it's theirs, even if they're the pig farmer and I know everything there is to know about pig farming, if I haven't talked to staff, said, hey, I know what, I think the application is missing these things because I know all about pig farming. Can you get that information in the record? Or can we get someone to testify about this? I want to be able to make that part of our decision process. And so I need to work with staff to get that into the record. Otherwise, it is ex parte. It is not in the record.
So I'm trying to think of an example. So ex parte, the individual is, as you said, an expert in pig farming. He talks to a neighboring county pig farmer and shares information or gets information or details from another operator that might be relevant for the current circumstance, but doesn't share that with anybody.
So having the innate knowledge in your own brain or doing your own research
would be ex parte.
Would be ex parte.
Okay.
Ross, what about Facebook, Nextdoor, Google?
Yeah, it's awful. So yeah, I mean, examples, newspaper articles, site visits, conversations with neighbors, when you have an application pending, you have to put your head down in Safeway and just walk the aisles. You can't talk to anybody. It's awful because all of that stuff is hard to contact. Facebook posts, sometimes a whole new Facebook group is created around a land use application.
Mm-hmm.
Surprise. No, that's not a shock. So yeah, all of that is ex parte, and letters to the editor, if there are still newspapers around anymore, and I think there are, op-eds, all of that is ex parte. And so sometimes staff will make the decision to help you all out because they know something is of community import. And so they will put a lot of this stuff into the record because they know you've all seen it.
So that earlier example where you had a commissioner driving by the property taking pictures, where initially it was used as another example, the pictures are the ex parte information.
Exactly. Yeah.
Okay.
So a site visit is ex parte.
Right.
So when the script says, please announce your ex parte contacts, the reason you do that is because you need to disclose those to everyone, the applicant and all the other participants. So they have the right to rebut that information.
Okay.
So if you're not a pig farmer and you are talking to your friend who is a pig farmer and learning all about it, when the chair asks for ex parte contacts, you say, well, I talked to my friend who's a pig farmer and he told me X, Y, and Z.
Right.
Now the applicant can say, well, that's wrong. And then during their testimony, they say, all right, I understand you heard X, Y, and Z. Well, I'm going to tell you A, B, and C.
Okay.
And that gives them the right to rebut what you just told the group. And so the important thing here for you all is to track. You don't avoid if possible,
right? But
track it.
Okay.
And then when the hearing comes, you have to disclose it and give folks the opportunity to rebut it. Now, just one final point, just to close that loophole. There's a period in your land use process where you have closed the record and you have not yet issued your decision. And that could be like a 2-week period. And you have one meeting where you close the record and you're going to come back and deliberate at the next meeting and make a final decision. Well, that is, you got to close it down. that is danger. That is danger zone. You got no trips to Safeway.
Take a vacation.
Take a vacation.
Don't turn on Facebook because now you have obtained ex parte information with no ability to disclose it, no ability for the other side to rebut it.
Okay.
That is danger zone.
Gotcha.
If you had personal familiarity with a piece of property, you lived next to it for 20 years, how would you express that ex parte?
Great question. I would do it in response to the question. So the chair has a script and ask for any ex parte information, and you would say, well, I've lived in this area of the county all my life. I grew up along that stream. I used to fish along that stream. I know everything there is to know about it. And so that would let the applicant then know, well, I've got someone who's really knowledgeable of this area on the planning commission, so I need to speak to them in my application, or someone else in the audience can address their testimony to you about that issue. We know you've lived there all the time, for 20 years, or all your life, but let me tell you why that's not relevant.
So Ross, I want to tag on to this. So this is one of the questions that Nicholas asked us to think about is, if one of you does have an expertise in an area related to an land use application, let's say you were a pig farmer in a previous life, you declare your ex parte contact, you state that you can be fair and unbiased, and you go forward. You listen to the testimony, you listen to the evidence, the record's closed, comes back for deliberation. I think the thing that you must be very careful of when you're deliberating is not to inadvertently introduce
New evidence.
Because you have such a depth of knowledge on a particular topic, it will be easy to let things slip that aren't in the record. It's okay to use that knowledge and your experience to analyze the evidence you've got against the criteria. That's just fine. But you have to be extra cautious not to bring in facts and based on your experience that are not in the record. Because technically then they become in the record and they're not rebuttable, as Ross said, and now we got a problem with the record. We've got evidence that's been introduced by a planning commission member after the record's been closed, and nobody who testified has a chance to respond and rebut. So I think that's the real danger of being an expert in an area that the application investigates. You can participate. Don't bring anything else to the party.
So to add on to that as a question, if that knowledge that you have, you think should be shared, is it best to share it when the chair asks about ex parte contact, or would in the staff report ask the staff to include it, basically provide written testimony or provide questions to the staff ahead of time?
Well, I'll let Ross answer as well. I really don't want to see any planning commission member give written testimony, because now you put into the record a biased position. And how are you going to rehabilitate yourself? You put into the record something that is for or against an application. So I would not recommend that. When you declare your ex parte contact, you're not bloviating all the information you know. You're only describing why you have a conflict. And that's different than imparting evidence. So you understand the nuance.
So I think there's a lot of different ways that this can come up, circumstances and to each their own in terms of how it comes up. But what I will say is I will put in a pitch for reviewing your packet as soon as it comes through the email or however you get your packet. And so if you see on the agenda quasi-judicial matter that you have a lot of familiarity with, a lot of knowledge about, or just experience about, read through the packet, see what the criteria are, and then give Patriot a call and say, hey, I think we're not asking the right questions here based upon my experience, based upon my PhD and whatever it is. I think we should be asking these questions. Can you help me answer those questions? And then work together with staff on finding those answers without having you testify. Good.
Could you please define keep track?
Yeah. So it kind of depends on how extensive. So, sometimes a land use matter is really intense and there's a lot going on. And so having a yellow sheet of paper and listing things out, because what you need to be able to do is declare the substance of the ex parte contact. It's kind of like the conflicts of interest. You have to state the nature of the conflict of interest. For ex parte, you have to state the substance of the ex parte contact. So you have to be able to be up there on the dais and say, you can't just say, I had a conversation with the applicant in Safeway. You have to say, I had a conversation with the applicant in Safeway about how many pigs they were gonna have, what kind of fencing they were gonna have. So you have to be kind of detailed. And so that is what keeping track. And so if you have, again, this is where the chair can probably work with staff as you're getting this application in the door. Staff can be saying, hey, you know, we've got this juicy application coming. We're gonna start building a extra record. We're gonna start clipping the newspaper. We're gonna start clipping Facebook. And we're gonna just throw that in the record so that you all don't have to keep track of it, because I know you're all reading it, so we might as well just throw it in the record now anyway. So that's a conversation that, you know, every application is different, but that's one way to head it off a little bit. I will also say, lastly on this, conversations with staff and your attorney are not ex parte contact by statute.
Okay.
So during that closed record period, you can ask questions to help you deliberate. How should we interpret this provision? How should we respond to this testimony? Well, work with staff on that. Work with your attorney on that. That's not ex parte.
Okay.
You have local flavor, you want to jump in?
I can. So we're 8:02, and I will go through this a little more quickly since you guys should be fairly familiar with what we do here in Benton County. So how many have not gone through a land use hearing yet?
The entire group has.
Just
Sarah,
one?
I guess, yeah.
Okay. So we've already talked about the application coming in and staff reviewing it for completeness, and that's the 30-day review period. So once that application is final, boom, then our clock starts, 150-day clock starts, and staff then begins to write its staff report. And so sometimes a lot of people misunderstand what a staff report is. Staff report is not the decision. Staff report is planning staff, and they're the experts, and nothing from you guys. You guys are the decision makers, but this is what they're trained to do. They take a look at the evidence, they look at the criteria, they reach out to the applicable agencies, ODOT, Dogami if it's a mining permit, and they get their feedback and their input, and they use that information to develop an analysis of the criteria based on the evidence that they have. And they set out the criteria. They tell you what sections of the code are being, that are relevant. Now, for your information, not every single one of the code sections that referenced is really relevant. Some of it is notice and, you know, timelines. The most germane section for you all are the code sections that describe the type of application, variance, conditional use permit, farm dwelling and EFU, and the criteria that you will use to, here it comes, judge that application. Staff report really provides that, like a brief, if you will, from the lawyer standpoint. Here are the issues. Here's the evidence. Here's how we analyze the evidence against the criteria. And here's a recommendation based on our analysis and the evidence submitted. And again, as Ross said, this is draft in the lightest of pencil forms, because all that staff has to go on at this point in time is the applicant's material. Once you have that in hand, now you know what the application's about. You're able to understand whether you have any conflicts, whether you've been involved with any of the parties, More importantly, you're able to understand what this is about, what you're going to be asked to decide. So that staff report goes to you via email, because nobody gets it by mail anymore, do you?
Oh, yeah,
Sometimes,
Really?
yeah.
Really? Oh, come on, this is 2024. Oh, my goodness, you're killing us with the postage, you know? So you get them, most of you, by email, and you had that opportunity to go through the staff report. When you come to the hearing, where are we at in our slide here? The next one.
Yeah, here.
All right. Now you've got the basic preliminary information, what the hearing's about. Come to the hearing, and as Ross has been discussing, you'll be asked to spill your guts about your ex parte contact, your bias, and your conflict of interest. Now, assuming you either do that successfully or you have none, and let's face it, the vast majority of applications, you don't have any of that. Now you get to the meat and potatoes of what you're here for. Now we get folks coming up and they will give you evidence. Now here's the real challenge for every planning commission in the state. What is relevant and what is irrelevant? That's your job. I can't tell you. The chair can't tell you. Each and every one of you makes the determination what evidence is relevant to a specific criterion. So I had a conversation with Evelyn, must have been 3 years ago, on this very topic. And I made the point that it's not up to everybody else. It's up to each of you. If you can listen to a piece of evidence, let's just say for the sake of discussion, somebody has come forward and they're testifying that this pig farm is going to be hauling pigs down I-5, and that extra weight is really going to accelerate the deterioration of I-5. Okay, maybe it will. But is it relevant? You have to ask yourself, can I make a straight-faced argument? Is it reasonable that that piece of evidence relates to the criteria? If you believe it's reasonable that that piece of evidence relates to the criterion, it's relevant. If you do not believe it's relevant, if you do not believe it's reasonable, it's not relevant. Everyone may say, yes, that truck on I-5 does relate to the undue burden placed on public facilities. Liz may say, of course not, and that's fine. That's fine. Because at the end, after you all have evaluated the evidence through your own thought process, you'll vote. Maybe Liz's argument has held sway with you. Maybe Evelyn's has. But that's why you deliberate. Liz can give her opinion on why that particular piece of evidence doesn't really relate to that criterion. And Evelyn can say, well, I think it does, and here's why. And you all exchange this process of digesting and analyzing the evidence such that you come to a very well-informed opinion. Not all evidence is relevant, but it's up to each one of you to decide what is and what isn't. Anything to add to that?
No, other than
Other than I went totally off script?
No. I think that, so deliberations can be, so at that point, after the hearing, you have a more finalized staff report that becomes the draft opinion, the draft decision. And that deliberation process isn't yes or no on that decision. It can be Evelyn making a motion to change the wording, the findings as to one criterion to address the weight limits on I-5, because I think that's relevant. And then we can have a discussion about changing the staff report as to that element. And then we can have a vote on that particular element. And now, okay, now we've changed the staff report on that issue. Now, anyone else have anything else to deliberate? Anything else that you saw was relevant? But that decision process comes with, number one, is there a criteria? And number two, is there evidence in the record? And number three, is there 5 votes in favor of that?
And for your information and for our newer planning commissioners, on complex applications in the judicial process, we modify Robert's rules slightly, and we close the record and go into deliberations. I will make the offer that any planning commissioner who wishes can make an opening statement. And the opening statement, you kind of, what evidence was persuasive? What evidence are you ignoring and for what reason? And the intent behind this is to streamline and make more efficient making of that first motion. So we get to deliberate on those things where we know either we have disagreement or we need further clarification through the discussion process. And we haven't done that in, probably 6 months. So we haven't had a complex application, but when we do, that is our process, is you have the opportunity to provide an opening statement.
And I like that variation on Robert's rules, and I will just say for the record, I hate Robert's rules. It's so archaic. But really, I think that the whole purpose there is to get all of you engaged and have the whole planning commission understand where each and every one of you is coming from. And you're not always going to be voting on the winning side, so to speak, but you know what? As long as your position is heard and everybody has a chance to digest it and then maybe, accept it or reject, you're doing your job. And at the end of the day, you need to be able to look the applicant and the opponents in the eye and say, I did the best I could. I'm comfortable with how I came to my conclusion. You may disagree, but this is how I analyze the evidence against the criteria, and I believe this because of these reasons. You're a body, you're not a group of 9 individuals, you're a body. So remember that, you're all in it together, even those of you who may be on the dissenting side. So the second bullet point there is I think critical, because in some of these complex applications, we get evidence that is completely irrelevant. And, again, getting to the 3 minutes for testimony, and I know some of you would like the chair to, cut somebody off who's talking about pig farming in Alberta, Canada, and how they've got this wonderful process of integrating goats because, whatever goats do with pigs, I don't know. And that has nothing to do with any criteria. Right, let them go 3 minutes, but that's the kind of evidence and that kind of testimony that never makes it into your discussion. It might be noted in the next iteration of the staff report or in the findings, just, Vance Crony talked about goats, ha, 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 but we wouldn't do that, would we? It would be noted in the record. It would be noted in the record, but it wouldn't be evidence you would consider. And again, that's getting back to what you consider to be relevant evidence, and that is it reasonable? Can you make a straight-faced argument that the evidence is reasonable? Findings, and again, the third bullet there, this is where staff comes in after you guys have had your votes, plural. I know a lot of times in these complex ones, you'll have multiple votes on various points of the findings that you wish to memorialize. Staff puts it together. So you don't have that onerous task of trying to write the findings, trying to annotate where the evidence is so that we have a complete record, or we have a finding that adequately references the evidence. So Ross mentioned you got to have evidence to support. You have to have substantial evidence in the record to support your decision. And that's a higher threshold than just 51, I think, than 51%. chances are you'll have some of those decisions, but we like you to be able to point to more evidence to support and far less that's opposed, if that makes sense. And staff will write it so that the findings support or show why the applicant has not met the criteria, and it will relate to that evidence. And then you will have a chance to review those findings and make edits and make changes, and then it comes back to you for that final approval. So nice thing about that is you have a lot of input. You have a ton of input all the way through the process. But here's the discouraging part. If it gets appealed, that's just another 16 pages in the packet that goes up to the Board of Commissioners. The board now starts fresh. We talked about de novo, you all know what de novo is. We got burned about, I'll say about 10, 11 years ago. We did not include the Planning Commission record in one of our findings. And when it went up to Luba said, well, this isn't supported by evidence. And we got it remanded. So we always, at the outset of the Board of Commissioners appellate hearing of your decision, we incorporate by reference the entire Planning Commission record, so that everything you do, everything you've seen is before the board in their packet. So, remember I said it's a little discouraging, maybe a little disheartening that your hours of deliberation, may just be a couple pieces of paper in the record. The board will see it. I can't emphasize that enough. The board will read it. So it is crucial. You guys are the experts down here. For your decision to be well-reasoned and to relate to the evidence and to focus on the criteria. I can't tell you how important it is to the board to read your findings. They do. They place a ton of weight on your participation, your expertise.
I would just dovetail, and maybe Pedro will kick me under the table for this, but the deliberative process with the Planning Commission is deliberative not only amongst you, but also amongst staff. And so I think that's important for you all as individuals, individual members, to know that as you're working towards that final decision document, there may be times where you say, hey, Pedro, I'm really having trouble with this particular criterion. I think I heard evidence to the contrary. Can you help me out? And Pedro can work with you on solving that issue. And maybe you can come prepared to that next meeting with a alternative draft finding that you and Pedro work together to draft, which I don't know, in my experience, I love that, because now staff is prepared for, we've got a draft decision, and then we've got, as to a criterion B, we've got two options, and they're both well drafted. Staff has gone over them, legal has gone over them, and now we just need to decide. And so if you know you're having a problem with a particular criterion, reach out for help, and you can help your colleagues through that. And maybe you don't get the 5 votes, but maybe you do.
And also, while you're deliberating, you definitely can call on staff to answer questions while you're deliberating. If you're unclear what a piece of testimony was, they can help you find it. If you're unclear what the criterion means in this particular case, staff helps you. So you make the decision, you deliberate, but you have tremendous resources. Draw on them. Right?
Betcha.
So,
I do really like that. Sometimes, instead of having to wordsmith in a meeting, which is so hard when you've got so many people in the room, is to have alternative prepared so that a lot less of that happens. So it's a lot more effort at the front end, but during the public process, it seems a lot more organized.
A lot. I totally agree, yeah. I think we can probably just skip to the end.
Yep.
Nicholas asked for some, what leads to an appeal? What can a planning commissioner know that will get the county in trouble and headed to LUBA? And so these are just what I came up with as kind of my top tips from my experience and what I've seen at LUBA, what I've worked through at LUBA. You know, I think the number one is not really for you, but you have oversight over it. But is someone watching the clock? Is someone watching this 150-day clock? And I really love, I love seeing it almost at the top of the staff report. When was complete, the date of completeness and the date that the 150-day clock ends, were any extensions granted by the applicant? And so our new deadline, if that's on the top of every staff report, that's great for staff, then that's in their system, but it's also good for you. Now you know why they're, you know, busting your hump about, you know, we need to schedule another meeting. As well, it's because that date's coming up. So, you know, and we talked about writ of mandamus, so a great way to stay out of trouble is keeping on that clock. Having a comprehensive record that addresses all the criteria. It is the applicant's burden. The applicant has the burden to present you with the evidence to support their application. So an application should be denied if there is not enough evidence in the record. So that is really their burden, but you have to watch them. And if you want to propose an alternative finding, you need to find the evidence in the record. So, you know, I've seen it a lot where a policy body gets an appeal and they don't like this application and they're going to find a reason to deny it. And so they propose a finding for denial, and staff looks up at them and says, okay, what facts shall we cite? And they can't come up with it because there's nothing in the record to support denial. So if you want to deny, find the facts. Weigh the evidence and the experts. A lot of times you have contradictory evidence. You have evidence, you have experts on both sides. You have expert pig farmer for the applicant and expert pig farmer for the neighbor. And they are saying the complete opposite. You need to weigh and pick one. And that's fine, but you need to do it. And LUBA doesn't like it when you don't. Because LUBA says, looks at the record on their own and says, well, I see evidence that supports both sides. What did you decide? I can't tell.
And
well, I better remand.
And that goes to the comprehensive record. If you have, at the very least, acknowledged a contradictory piece of evidence and at least found that it isn't credible or isn't relevant, then you have eliminated a potential bone of contention at LUBA or the Court of Appeals. So you don't have to dwell on these things. You just have, you know, while you're deliberating, you say, gosh, you know, pig farmer A, I thought he was great, had 10 years of experience in Oregon. Pig farmer B, she just started her business and she came up from California where she was selling jewelry. So I'm not sure I'm credible. There you go. You're done. What was that? 7 seconds? And that's in the record. That's in the record.
Again, staff is largely in charge of the final decision drafting document, but it's yours. And so you need to check up on them. You need to make sure that it's thorough, that it addresses all the criteria you think it should address, and it does so consistently. So that is something else that LUBA hates, is rulings, findings on 2 different criteria that seem to be saying the opposite thing. How can that be? That's not internally consistent. And so as you pour over these different versions of the staff report that then turn into the decision document, that is one of your jobs, is to make sure that those findings are consistent. And then lastly, if you're going to propose a condition of approval, LUBA loves to remand when it's not clear or when it's potentially discretionary with no public process on the back end. So like a condition of approval, we're approving this pig farm conditioned on them producing a site plan with proper fencing. Well, what is proper fencing? And who's going to determine whether it's proper or not? That is both unclear and discretionary. So that is a bad condition of approval.
How would you make it better?
By being clear and objective, by saying, according to the site plan attached as Exhibit A, the exterior pens shall have 5-foot fencing of this material.
6 to 2 feet from the property line.
Right.
Yeah, to be approved by Public Works.
200 square feet.
With the setbacks and all of that.
Yeah, and so it's not, so you've identified who's gonna look at it, and it's gonna be objective and non-discretionary, whether they check the box, yes or no.
Is that the kind of thing you could ask staff to find the details for?
Oh, yeah, absolutely. Yeah, absolutely.
And chances are high, the information is already in the record,
There
that
should be,
describes
right.
how that condition will be written.
Yeah,
Or the applicant has produced it themselves.
right.
Yeah, that's the other thing. A lot of times, when the application is approved, I don't know how Darren does it in the past. We've asked, a lot of times asked the applicant to write these conditions. Takes.
Well, if they have professional expertise, so if they have counsel,
Sure.
they have a professional planner, it's a little easier to ask them to do that work. If it's, just a property owner, we don't usually ask them to do it. We do it for them. But a lot of times if they can afford professional help, they've invested a lot in it, and then they kind of want to write it anyway. So,
Yeah, and the other thing about that is we tell them what it needs to be. They know what the condition needs to be. And chances are high, when we do that, that's going to be appealed, and they're going to be defending that condition at LUBA. So and I'll tell you right now, conditional use permits, variances, I don't go to LUBA. That's between the applicant and the opponents. Now, I'll defend comp plan changes, map changes, zone changes, things that affect Benton County, but things that affect the individual properties, it's up to them, which is another reason why we asked them to write those conditions. And Ross probably cringing at that, but
No.
it's just me, and I just don't have the time for it.
Well, my clients have to pay me for it, so I'm, if they want to save the money, I'm fine with that. I just want to say, I want to end by saying, I love this. This is one of the favorite parts of my job, is coming and talking to folks who are volunteers and love their community. And so this just fills me with warm fuzzies inside, and I will feel good all night. So I really appreciate you having me here, and I appreciate Vance's expertise here. I think you've got great staff. Use them. And I thank you for not glazing over. You were engaged the whole time. I think that's fabulous. 2.5 hours. Good job. Pat on the back. So thank you very much.
And we're gonna get our OCEG certificates from you.
You are not.
Thank you both very much.
Thank you, Ross. Thank you,
fulfilled
Vance.
the objective
Thanks.
nicely. It's always good to have more continuing education for the planning commissioners. So we will adjourn without objection the work session. Then we'll take about 5-minute bio break, and then we have some business items in a regular session. All right, so try to reconvene.
Thank you, everyone.
Yeah.
I think if I go over 4 minutes.
I was like, I should have brought eye drops or something.
Yeah, I know my contacts are.
Yeah. they're a little sticky. I figured, I was guessing.
There's a seat here.
Okay, I think we're all back, so we can reconvene as a regular session of the planning commission. And we just have a few things to go over. I know that we are exceeding our time limit and we're getting to my bedtime.
Yeah.
So the first thing on our regular meeting agenda is to consider and approve the minutes from January 16th, 2024. Are there amendments, edits, corrections? I did catch that the subtitle discussion of planning commission activities, I believe that should be 2024 and not 2023.
Yeah. Done.
That was all that I saw.
I always feel a little lazy and think Evelyn's gonna spot something.
I know.
So,
And entertain a motion to approve.
move to approve.
Second, any further deliberation? Call for the vote, signify by aye.
I,
Any abstentions? Very well. Now moving on to the next section, which is entitled Subcommittee Appointments. This came out of both our prioritization sessions that we've had roughly annually and we just looked at the minutes from January 16th where we reviewed the priorities and a number of the initiatives that looking forward are both on our plate as well as community development's plate. And the short bumper sticker is there's a lot going on. And it's an exciting time because there's a lot of things that the Planning Commission and its members can contribute to directly. And a couple of the major initiatives are sufficient in scope, in breadth, and importance that I have been talking to Director Nichols and decided to stand up 2 subcommittees of the Planning Commission. The first subcommittee will be one that has been on anyone's and everyone's talk list around the state, around the Planning Commission, the legislature, everywhere, which is the broad topic of housing, availability, affordability, and there's lots of data to demonstrate that Benton County has this issue in spades and merits some special attention from the Planning Commission. So I've invited Commissioner Fulford to lead this subcommittee. And once I introduce the other subcommittee, I'd like Commissioner Fulford to go through kind of a skeletal, what's the charter, what's the committee going to focus on, how can all of us participate in the activity. The other subcommittee we've also talked about at length. It has to do with the periodic review and comprehensive plan, code updates, and making our development code much more accessible, beginning to change the perception that persists in the county that some of our development code is less than accessible, less than clear, less than objective, and so forth. And also speaks directly to the third leg of the Planning Commission stool, which is citizen engagement. And I've invited Vice Chair Heyman to lead a committee on code and comprehensive plan activities coupled with the outreach to the community on citizen engagement. So 2 subcommittees of vital importance, opportunity to contribute strategically to the county, and leadership from both Commissioner Fulford and Vice Chair Heyman is going to be critical in getting some activity and moving both of these critical initiatives forward. So Commissioner Fulford, could I ask you to kind of review your preliminary thoughts on this subcommittee?
Yeah, if you don't mind standing, I'll stand up and kind of go through it real quick. And I appreciate the trust on the appointment for the subcommittee chair. So I've got a few slides, you know, it won't be a couple hours, it'll be hopefully about 4 or 5 minutes. And I'll kind of hit on the high points, but it's an early draft. It's as Chairman Fowler said, it's a skeletal first pass at it. So regional affordable workforce housing, this is the charter doc, or the charter slides at least. So let's go ahead and go to the second one. The agenda, basically goal, purpose statement, why are we doing it, right? A little background information, including business case, you know, benefits and risk, benefits of doing it, risk for not doing it, and a work plan or next steps following that. And so this goal or purpose statement, right, it's Benton County, but it's really regional. Right, and so it's the counties surrounding Benton County. It's Lane, it's Lynn, it's Lincoln, Marion, Polk, all the counties that really surround us. And it's really our charter, our opportunity to meet some short-term and long-term housing needs. Really work for the community and develop some things. But it's not just our city or our county. It's really a regional challenge.
Oh,
what's
it's
that?
Right, it's right there.
Oh, cool, thanks. So some background information. As we know, increasing pressures across all levels of housing, right, in Benton County and pretty much the region, right? Employees that work near Corvallis run into fine affordable housing. I think, Darren, you said it really well. 26,000 people come in and 6,000 people go out every day. And, you know, from Sweet Home to Lincoln City, Dallas to Springfield, right? It's the whole region, right? And so all sorts of problems, we can hit on more of those, but service workers, firemen, teachers, right? All the way to the professors at OSU, engineers at HP, doctors at the Regional Medical Center, right? And if we're not concerned enough, the community will start really dividing between have and have-nots and really threaten our stability over time. Business case, this one's pretty interesting. You know, I leveraged some of the research from the county on this, but we're the second most rent burdened county in Oregon, severe deficit of workforce housing. And the big players in town like OSU, HP, the Regional Medical Center are feeling it, right? They go to hire people and they go, let me see, I can either commute, you know, half an hour in from Sweet Home, or I can get a job down in Eugene and bike to work. And why am I doing this, right? And so I actually did some math here. The AMI for a small family in Benton County is $68K. 80% of that is basically a $148K home, right? 120% of that is a $274K home. And so developers are like, the land's gonna cost me more than that. I can't make this dollar hunt. And so big issue, so that's the business case. So benefits and risks, you guys can kind of read through these. It's a broader issue. It's a regional level, multiple wider price points. What we want to do though is leverage some existing investment, share efforts and costs and solutions across the counties and cities, right? And hopefully with the larger cooperation at the regional level, with larger investments in this. And also this part here, strengthening the conservation efforts. If you just do a city by city, you start to walk all over the wetlands and various areas that we really need to conserve. And if we have a regional plan, we can really protect that a little better. And the risk if we don't do anything, right? Well, we can read through those. The quality of life, this one's really the strain on the social services and health problems, right? At have and have-nots. You get people that don't feel like they belong, they start stressing out. Even the businesses, right? If the whole county area starts to get older, we want to get younger people in, all of a sudden businesses start to suffer, the services start to suffer, and they have to adjust. So there's some risk in that. This is the work plan, sort of next steps. I think step one, identify planning commissioners and community partners. That's starting to go on. Develop a communication strategy with purpose is number two. Appoint a subcommittee. We're starting to build that, starting to get some soft invites. And then once we get that built here, we start taking, setting up agendas for meetings. Then if we do it right, we have a plan that we can actually go hopefully to the state or the feds and start to get investment as well as local private investors as well. And hopefully we incorporate it in the plan and start executing on it. Just lastly, Q&A, feedback, thoughts. It's an early draft, so it's open, but it's pretty quick, right? But you guys thoughts on that?
Yeah. I want the graphics.
It took like a half hour to draw.
I'm just
right
surprised.
So thank you.
Yeah, thank you.
And thank you for doing that. I invited Patrick Wingard to join us tonight in part to kind of hear some of these planning commission interests. In part so that DLCD can kind of sort of come alongside as a partner in the periodic review and through, other grant programs, help support the planning work that needs to happen. So I just want to kind of make the connection to Patrick and make sure that's, part of the reason we asked Patrick to come.
Oh, yeah.
Yeah, it's really nice work. And you just developed that yourself,
Well, we leveraged some of the.
okay, because that's a great start. You're obviously well on your way to thinking about what some of the, challenges are and how to leverage partners, convene meetings and bring solutions. Yeah, and having this feed into a potential periodic review work program.
Oh,
it's great.
Every single planning commissioner with whom I've spoken had housing on their list of concerns, of priorities and so forth. And so now we have a subcommittee vehicle to begin to channel that energy and ideas, move that ball forward. So thanks for taking on a challenge. It's a big, big goal. Lots of voices that want to participate. So our second subcommittee is on code, comp plan, community engagement. So Vice Chair Kingman, would you like to outline this subcommittee?
Thank you. I don't have a presentation, so you'll just have to listen to me. But I appreciate your reference to LCDC because clearly this work is going to be have to be like this with you, the work with your group because. And so I sort of started with the thinking about, so why are we doing this? And I think there are two things that are either true or at least perceptions. And they are, one is current code is sort of complicated in different places and hard to access. So it's hard for people to know what the code is. And I think and then the other perception that may be true is that it may not be absolutely up to date. It may not be, it may not be written to anticipate or understand the current challenges or the future anticipated challenges we have to think need to be addressed in a good code. And I've only been here 2 years, year and a half now, but I think I've had permitting requests that I could have just kind of wished that code gave us a little clearer direction and definition. And I think I think even within our commission, there's a sense that we can probably make some progress there. So I think that's the why. We have 3 stated goals. One is to provide an easy and searchable access for the Benton County Development Code. So that addresses that first issue. You're going to find it, you're going to be able to search it, and that should make it. We should be updating the code. This is number 2, to reflect legislative updates. That I'd like that skeletal graphic, the only color graphic in the presentation. That here's all the things that are above us. Well, that stuff keeps changing,
right?
And we have to make sure that our code is consistent with that. And so that's, I think, the second goal. I think the third one is what, Chair Fowler addressed specifically with regard to community and public engagement is how do we make sure that this code is addressing the interests, the concerns, the values of the community that we serve. And so that's going to, and that sort of is like connecting with the community with a future focus, like how do we make sure, and that's going to require, a lot of community engagement, which is part of our job, and then making recommendations with regard to what that might look like in terms of code. So those are three goals. Only three, probably big ones, or at least some of them. We have a work plan, and they're sort of different in the sense that the level of our committee's direct involvement or direct responsibility. The first one is just support the implementation of online search engine, search code. Clearly, predominantly staff work, but it falls within the domain of this group, and so we want to be engaged with that. But we probably don't take the lead in that one, but it's a critical piece. The second is incrementally update code for compliance with the legislative actions. Again, that's sort of a partnership between, I think, our committee and staff to make sure that that we're, well, one of the things that's going to happen after, it's going to prioritize, it's like if we have a couple dozen changes we need to, which one do we need to do first? What's the most important one? So that'll be a part of that work. Then the third one is to try and assess where we'd like to make recommendations that code would change. And I think there's a number of processes that we're going to need to be engaged in order to do that. The first one is one I've sort of already referenced is our collective experience with our quasi-judicial work. Are there places in which we sensed inadequate or outdated code? And we want to bring that knowledge and that experience to this process. So that's one thing. And we want to engage with the community to again see where code might need to be changed to address their public attitudes and concerns. I think the third one has to do with how has the world changed since these codes were written? I'm looking at my draft and it says this hasn't been updated since XXXX. We didn't put the date in yet because I don't know what it is, but I bet it's been a long time ago. So we can throw out examples. I'm not trying to prejudice the process, but we think differently about wildfire. We think differently about climate issues. We think different about water issues. And I think, those are three obvious ones. Will that impact or inform code differently in the future? And so I want to bring those kinds of things into that. And then the last is sort of partner with the housing committee to see where code changes might need to be enacted to address what your committee is doing. So that's the plan. And glad to, if you have comments or questions.
Marty, great job.
Thanks, Commissioner Hammond.
So quick positive update. We are about 1 day away from signing a grant agreement with DLCD to provide the $50,000 to support the community engagement, which goes a long ways to helping this committee advance its work. So Patrick, I don't know if you want to talk a little bit about that or.
Yeah, sure. For the record, Patrick Wingard, Department of Land Conservation Development. Yes, so congratulations. You outcompeted a lot of applications. The department has a biennial technical assistance grant program, and it's always oversubscribed. We get about 3 to 4 times the ask of what we can accommodate, but you all received a $50,000 grant award. One of 3 grant awards in the region. Crestwell received 20 grand and Cottage Grove received 60,000 because they have an economic development plan that's out of date and they're one of our key cities that's growing at a certain rate. But clearly, Darren, your interest in commissioners, your accommodating, I think, your director's interest in taking a look at this periodic review, statutory, and I'll put in air quotes, requirement, is no longer a requirement because it hasn't been funded. The legislature just, I think it was in 2002, 2004 session, just decided, politically, we cannot force county commissioners to adopt, ordinance changes they don't want to adopt, or cities. We need to come up with a different approach. Well, then measure 37, measure 39, landowner petition claims sort of consumed our time for the next decade or so. But now, we recognize at the department, our commissioners, we have an excellent commission, Land Conservation Development Commission, LCDC. We were encouraged as regional representatives where we could to either engage, embark in, or hear any community out who might be willing to consider a periodic review endeavor. And I'll say endeavor because the standard way for a periodic review program to move forward is through the adoption of a work program. And Commissioner Hayman, my good friend Greg, we know each other from the North Coast previously, so I'm really excited, Vice Chair, that you'll be heading up this committee, because it's so refreshing to hear you all, and I believe you 100%, to hear you all at the outset say, we're going to figure out through appropriate community engagement, we're gonna be inclusive and we're gonna be transparent. We haven't decided what we're gonna focus on yet. We know we have, a dozen or more, high priority issues, maybe 24 for you all. We have 19 statewide planning goals, 15 of them apply in your county, and I bet you at least have, every one of those planning issues from just, cleaning up your code so the procedures are more straightforward and more objective, to getting some of this tougher stuff like economic development and natural and cultural resources, housing, public facilities. I mean, it's something that our commission will receive very well, because if you follow through with this, and Darren, I know we've got a scope of work for your grant. It'll be executed soon. I think we're just about there, days away. But I purposely wrote it so that it provides you flexibility to, as you get into the process, to pivot and to be able to focus on the areas that you need to focus on. And frankly, Darren, if this entire project is an effort to engage the community, make sure that your priority populations have been attended to, people that can't get to meetings or choose not to come to meetings for whatever reason, they're intimidated, they don't have the financial means, to be looking out for those priority populations and incorporating, their needs and desires into your work. That's something that is just music to our ears, because we know as a profession, as land use planners, we've done some naughty things, have we not, over the years? And so, we feel as a profession, our commission feels strongly about this, from our indigenous peoples who have lived in these areas for thousands of years before us, to now how, we're trying to make this place that we call Oregon suitable for all people that live here. There's nothing more important in the work that we do than this right here. So, I'm thrilled, my boss is thrilled, our director, Dr. Bateman, is thrilled, and our commission knows that you're pursuing this and or has at least a grant to explore it. This is potentially something that could be a game changer in Oregon. If we can find some successes here, like I said, Cottage Grove got a similar grant. They also wrote into their grant, we're going to explore periodic review. We know we've got this economic development plan out of date, but there's other things we need to do in Cottage Grove. So I'm not only looking at this like, what is going to be important and the best outcomes for Benton County, but also how does this work maybe potentially influence others around the state? So, so I've got my focus with you, but I'm also thinking about ways that the fact that you're a county plans are severely out of date. Cities have been able to cobble together stuff because legislation that affects cities is more clear. legislation that affects you all on the exclusive farm use and the forest zones, the regional planning, regional problem solving, that is complex. And that does involve, regional partnerships in order to get to where you need to go. So for a county to take on a potential voluntary periodic review work program is really, we couldn't have asked for a better scenario. Because cities can get their work done in a way that doesn't necessarily, it can be insular. It can be. You don't need to be a regional partner when you're a municipality. But you all, just by your nature, are regional planners. So, and so are we. So that's again, just a really positive part of the work that you're doing. And I'll be like a bad penny, right? I'll show up everywhere. I mean, I already mentioned, Greg, that we know one another, but I look forward to getting to know all of you. And I want you to know me so that if during a presentation or another state agency partner, anything that the state of Oregon maybe is doing that doesn't set well with you, I want you to be comfortable. I know you are. You're right. To call me or through Darren, through your staff and say, you know what, we're just, we'd like the state of Oregon to approach this a different way. And I will absolutely advocate for you. I will be your advocate.
Thank you.
Yeah, that's about how I feel. I guess that's what I've got. It's kind of
Sounds like we have someone in our corner.
Yeah.
Yes, Patrick's a champion.
Yeah.
Thank you.
Yeah, I'll say this, Vice Chair Heyman, you do have me in your corner because Oregon's land use program, our statewide planning program, doesn't exist without your comprehensive plan, without your development code, without your planning commission, without your citizen involvement committee, engaged in doing the work that you're doing. Our planning program just falls apart without having cohesive plans at the local level. So this is where Oregon's planning program resides, even though folks will say it's a top-down program. And it's hard to argue on some of the stuff with the EFU rules and stuff. Yeah, that really does come down from on high, but really the way that you're looking at, engaging your citizenry, building a periodic review work program that helps you prioritize with your citizens, with your neighbors, areas that you need to focus on, areas you need to provide capacity, funding. It's really cool that at this point in time, you're willing to take this on, because I think you all have a sense of just, how much work is involved and the time that it's going to take. And I would offer, promise, the last thing I'll say, every second, every minute that you spend will be time well spent for your citizens. These are issues that counties largely have not been able to attend to because the funding is just dried up. And you all have so many demands on you from health and human services and on transportation, that sometimes, planning just has to take a backseat. Parks planning, land use planning, sometimes we have to, idle a little bit while other, more pressing items are dealt with. So it's just great that you're at this point and you're ready to do something that really considers the long range consequences of these short-term decisions you're making. So good on you. And yeah, you got my full support.
What funds the grant program?
So it's general fund. So you taxpayers, yep, it's general fund dollars. We do have dollars that come from the federal government for some of our transportation grants, but this is State of Oregon General Fund. So this is taxpayer generated revenue.
Thank you.
I certainly want to thank both leaders of the subcommittee. They've signed up for a lot of extra work and time and energy and coordination. There'll be ample opportunity for all the planning commissioners to provide input to both subcommittees, and we'll ask for periodic updates to the planning commission of their broader work. I know it's late. It's very late for me. Are there any topics from the planning commission? Any topics from community development?
No, I just want to confirm, you asked me last time which staff would be appointed to each of the subcommittees. So we're going to approach this as a team. Petra and Shannon and I will be working together on kind of the whole thing. But for housing, I'll continue to be your point of contact with help from Petra.
Okay.
For the rest of it, it'll be Petra and Shannon, depending on the code updates, going to be primarily Petra's. The community engagements going to be primarily Shannon's, But again, we'll very much work as a team and we'll have other partners with us. So yes, just reach out, please.
Thank you. So without objection, we are adjourned. Thank you for productive evening.
Thank you.
Thank you very much.
So we nominally have the first.
I'm not sure. We should probably follow up with Darren.